Ready? All right, good morning, everybody. Welcome to the March 17th, 2026 meeting of the Governance Committee. I am calling the meeting to order at 9:07 a.m. We're going to go through opening procedures and then we're going to take a short recess until none of our board members can join us. So to begin with, roll call. I am Leslie Reckler. Trustee Clerk Gonzalez Hoy is delayed and will be joining us shortly. Moving on to land, labor, and body acknowledgement. We recognize that we are presently on the lands of the Chochenyo, Muekwa, Harkin, Ohlone peoples and acknowledge them as the first inhabitants of the land we currently occupy. Labor and body recognition. I acknowledge that the burden of environmental exploitation and systemic injustice falls upon the labor of Black and brown bodies and the building of this country and its institutions. I remember that Black and brown people were born and died working this land against their will for generations. I acknowledge the continued contribution of the labor of survivors over the centuries to today of all immigrant labor, voluntary, involuntary, traffic forced, and undocumented peoples in the building of what we refer to as the United States. Author, Dr. Rochelle Boudreaux. 2, public comment. Is there any public comment?
There is no public comment.
Okay. At this point, we're just going to pause for a few minutes until Trustee Gonzalez Hoy is able to arrive. I'll check back in at 9:15 and we may delay further. So we'll be back at 9:15. Thank you.
Hello, everybody. I apologize for being late. I was also stuck in traffic. We're going to start with Mirabelli versus Bonta. And then we're gonna move to the few hundred mandated policies. So we have Ed Escolar from Lozano Smith. Thank you. I was like, oh geez. I feel like at this point I should really know that. Lozano Smith is gonna speak about the Mirabelli versus Bonta decision, which happened a few weeks ago, and how that affects our system. So pass it on to Mr. Escolar. Go ahead.
Sure. So thanks for having me here. What I wanted to talk about the Mirabelli decision, kind of give some context for it. Talk about basically this is still being litigated. So there is a their decisions have been made, but right now in front of the Ninth Circuit is, and I'll talk about this a little bit, is an emergency motion to clarify some of what is in place. But basically it started as Mirabelli versus Olson. Mirabelli versus Olson really deals with the obligations of a district and teachers and the rights of parents in regard to the discussion between the district and families about gender identity and gender presentation for students. And I think it would be good to start that conversation in the context of what my understanding of what California law was back since 2014, when AB 1266 was passed and the California Department of Education was providing guidance to school districts, basically saying there would be no disclosure of a student's gender identity. That was the student held the primary privacy rights. And so, but in 2025, things changed, right? And so in 2025, you had a group of teachers and parents in Southern California who filed suit in the Southern District of California in the federal court for the right for the teachers, looking for the ability to be able to disclose a student's gender identity, gender incongruence to parents, and the right of parents to be informed of their students' gender identity and gender incongruence. And in what they did was, as I said, they sued the state of California. That included the CDE and the state of California. So that's how it went from being the Olson being defended, what I presume was the superintendent of the district down in Southern California, to Rob Bonta being the main respondent, the Attorney General of California. And what the teachers and the parents were claiming were free expression, that it was a FERPA violation not to provide the information to parents, and that there was a restriction on parents' rights under the Mahmoud decision, which was the decision that you all recall the US Supreme Court came down with last year, that I would say greatly expanded parents' rights in the educational school. So the US District Court in Southern California found for the plaintiffs, determined that teachers have the right to disclose students' gender identity to their parents, that the parents have the right to be informed of that information, and that the state of California may not require school districts to maintain confidentiality of information about gender, student gender presentation. And I'll state directly from what they said, that the court said an LEA must refrain from enforcing any laws, guidance, training that would include prison training, which is done by teachers 7th through 12th grade on LGBTQ plus inclusion, that they must refrain from training or guidance that would do the following. And this is directly quoting from the law, from the court, sorry. Permit or require any employee in the California statewide education system to mislead a parent or guardian or of a minor child about the child's gender presentation at school, including lying to a parent, refusing to provide information when asked, refusing to provide student records, and allowing students to go by something other than their legal name and pronouns assigned at birth, if a parent objects. Okay, and you can talk about that in a bit. Also, the court said school districts are restricted from permitting or requiring anyone in the California state education system to use a noun or pronoun to refer to a child that does not match the child's legal name or pronouns where the parent or guardian has objected to such use. So this changes everything, right? This is a sharp departure from what the CDE's guidance has been, and what basically the law in California has been since 2014. Procedurally, the state appealed to the Ninth Circuit Court of Appeal, which is the appellate body for the district courts in California. The Ninth Circuit Court of Appeal stayed the lower court's ruling. So they said what the lower court, what the district court just said about the rights of parents and the rights of teachers to disclose students' gender identity is stayed right now until the appeal to the Ninth Circuit is heard. The respondents as in the teachers and the parents who were pushing the matter, or filed the litigation, and were opposing the appeal to the Ninth Circuit. They went to the Supreme Court of the United States, and the Supreme Court of the United States overturned the stay, basically saying that what the what the lower court said, that about parents' rights and teachers' rights, that they do have the right to disclose and parents have the right to be informed, that is now in effect. What happened shortly after is that the state defendants, the state of California and CDE, filed what's known as an emergency motion with the Ninth Circuit to get clarification and to seek amendment on the ruling the ruling from the lower court. And we don't have a decision on that yet. I'll tell you what the issues are right now at bay, which is why things are kind of on hold in regard to the breadth of what the district court's decision is. I was expecting to hear from the Ninth Circuit, or my firm was expecting to hear from the Ninth Circuit by last week. That didn't happen. So basically, we're probably in the next few days or in the next week or weeks, we'll hear from the Ninth Circuit on these two issues. One is the state, the CDE and the state of California we're seeking an amendment to the lower court's ruling that parents have a right to disclosure when they wanted a permanent injunction in place while the Ninth Circuit was hearing the case, insofar that that information about students would compel disclosure to a parent who would engage in abuse. Okay, so because right now, those protections are not in the court decision for what happens if we disclose this to a parent and we're able to articulate concerns about physical or emotional abuse of a child. So the state is trying to get the Ninth Circuit to say something about this. My understanding is it was either the lower court or the US Supreme Court. I think it was the lower court, did not put anything into place in regard to concerns about abuse, because they just basically said there are child abuse laws in place, and if the district has concerns, then those mandatory reporting obligations and other obligations regarding child abuse will be put in place. But that's not going to, but they didn't have any language currently about concerns about abuse, and that's what the state defendants are looking for. The other thing that the state is looking for clarification for from the Ninth Circuit is the lower court had a statement in their decision that said that in the notice, so in the notice that all school districts had to have in regard to prison training, is that parents and guardians, this is the lower court decision, parents and guardians have a federal constitutional right to be informed if their public school student child expresses gender incongruence. So the state is like, wait a minute, does that mean that during prison training, we have to, that the district employees, we're telling the district employees that they have an obligation
Right.
to proactively, affirmatively inform parents if they notice any gender incongruence or gender identity that is not consistent with how the child is identified at home? Do we have an affirmative obligation to then go forward and tell the parents, even if the parents haven't asked? So that right now is being decided as part of the emergency motion for in front of the Ninth Circuit. That's what we're waiting a decision on. If the Ninth Circuit, if that gets decided that, yeah, there is an affirmative obligation to notify parents whether or not they asked about their child incongruence, because it's called a medical condition that you have to inform the parents on, that would be a game changer, right? That would change a lot, and you wouldn't. And so I think that it would present a lot of districts with issues from teachers in regard to actually carrying that out, right? But it would also be something that we would probably need to put into policies and administrative regulations. So for right now, this is what we are. Well, let me tell you what the guidance is, and then I'll tell you about how we're advising districts to move forward. By the way, as I say this, I looked at certain district policies, 5145.3, 5145.7, and 5125, all which have to do with gender discrimination, also have to do with student records. None of the language in that right now is inconsistent with the state of the law. So, there may be language that will need to be added once everything in Marabelli litigation plays out and is in its final disposition. But for right now, CSBA, our firm has not put out any, you need to change your policies right now. And the district, like I said, at least on those BPs and ARs, I don't see anything inconsistent with the current state of the law. But CSBA put out some pretty good guidance that I think I just wanted to read through, that sort of talks about what are the practices moving forward. These things are in place. If asked by a parent or guardian, refrain from misrepresenting information about a student's gender presentation or incongruence. Now, one of the things that districts are going to have to think about, and that we've been talking to districts about, is, was that conversation had with the teacher, a specific teacher at the site, or was that conversation had with the site administrator, right? And so that's something that, in giving guidance on this, you may want that to be a conversation, as opposed to leaving it to individual teachers, having that conversation with the site administrator. And there's nothing to preclude that from happening under the current state of the law. Also, be aware of parents who have stated an objection to the use of certain names and pronouns for their student, as the court's order requires LEAs to respect those objections by parents. LEAs may receive notification from parents that they object and should be prepared to notify staff of such objections. So that gets to what I was talking about before. There can still be rules in place that say employees need to identify students by their preferred pronouns and how they themselves identify themselves. However, if the parent reaches out and says, I don't want my student to be notified, to be addressed by their current or their preferred pronouns or their preferred name, then the district is obligated to notify, to follow the parent's wishes. LEAs that have policies that require staff to use a different set of preferred pronouns or names when speaking with the parent or guardian than is being used at school to conceal a student's gender presentation are not legally compliant. In other words, you have to be consistent with the parents, and if you're speaking with them at back to school or just having an in-class meeting to let the parents know the gender identification and the name that you're using for the student, and be consistent when in conversations with parents. Parents have to be informed. If a school has told a student that they will keep that student's gender presentation or incongruence confidential from the parent or guardian, that student should be notified of the change in law and notified of these obligations. Now, with all of that said, this also only deals with confidentiality and disinformation to parents. It does not open up the door to disclosure of this information to anyone outside of the parent, right? So we still have our FERPA obligations. We still, other people other than parents or guardians are not entitled to that information about the student's gender identification and any of that information. So what we have been recommending to districts is that they review their district, the BPs and ARs, which contain the provisions regarding students' rights relative to gender identity, review the, and also the BPs and ARs regarding student records for the same purpose. Review any currently operative training slide deck for compliance and potential changes. For example, prison training, and if we have that, making sure that it does have the information that basically says parents have an absolute right to access their students' records and be informed on the gender identification of their child. Review the district's gender support plan for compliance and potential changes. Once again, notifying students that of this new development in the law, and that there can't be an absolute guarantee of confidentiality. Review any guidance memorandum or other directives which the district provides to administrators or teaching staff relating to those issues. And look at the district's web pages, which may contain information or content impacted by the court's rule. So that's the guidance we have. And like I said, waiting for the final disposition of this matter, particularly in regard to, please, there is an affirmative obligation to notify parents of any type of gender incongruence, even without the parent inquiring, and we'll keep the district updated.
Thank you.
Yeah.
Thank you.
Any questions or?
Any more questions? We'll start with you.
Yeah, just does anybody, I mean, the reason why I called for it was I thought it was important. If anybody here in this room has questions, feel free to ask them now. I mean, a big question for me is what makes teachers and staff experts in this? And I feel like there's gray area around behavior and having somebody report when it may be a joke or a phase or a, like,
Right. Which is-
I feel it's a slippery slope.
Yeah,
to identify that when you're not an expert in gender?
yeah. And, you know, so these very real life scenarios are gonna come up. I don't think the court defined like, when do you know, when are you obligated? I think, and I don't know what would. So if a parent inquires, maybe telling them of an incident or an episode of, and once again, leaving that with the site administrator to have that information if the parent inquires. But yeah, like when is it, if a comment is made in class by a student, like that'll be a really big question when, if the Ninth Circuit determines, yeah, there is this proactive affirmative obligation to notify parents. I don't know where that is going to, where the affirmative obligation will, then, and we'll have to see what the language is.
Okay, you mentioned, child, abuse laws and mandatory reporting. And a very real scenario, has come up for me personally as a principal, I know for several of my colleagues, in having conversations where they have disclosed on the front, children have disclosed on the front end or intimated that harm will come to them if their parents find out about this, right? And so my question is, does that potential harm to the child preclude or supersede any requirement of reporting to parents, right? So is the law saying you have to report the parents and call CPS, or do we not tell the parents because we know that there's potential harm as reported by the child?
So if the child is identified abuse by the parents,
I'm sitting in my office.
yeah,
Kid says, if my dad finds out about this, he's going to kill him,
yeah, yeah,
right? And so now I, as the principal, have, and this is, 6, 7 years ago, and there were, the laws of 2014, 15, 16, I was able to have that conversation in a very different way than I would have to have it now under this new law, this new ruling, right, potentially. And so if I know that disclosure of this information puts the child in harm, does that safeguard me as the administrator, the school district, to say, actually, no, we have not only moral and ethical obligation, but a legal protection here to not follow this particular ruling because, child protection supersedes.
I think in scenarios like this, like. My rule has always been child safety comes as paramount, right?
Right.
So, but if we're gonna do that, and if it's going to be, the child makes that statement, like documenting all of that,
Mhm.
because if it comes back, you wanna be darn sure that you can articulate facts to indicate. This is a little bit beyond just a suspicion of what is going on, like, here's what the facts I had in front of me, the child's statement, maybe prior history with the,
Mhm.
dealing with the adult. That can articulate, I had a really valid concern about potential abuse here, and so I didn't disclose. I think that, if you can do that, I think we'll be okay. Someone will be down the road, I think you gotta document it all.
Yeah.
Somewhere down the road, the parent will say, the kid simply made a statement that my parents are religious and, it's going to, I think you wanna be able to articulate really good facts to support why you didn't report. Or
I
why
think-
you didn't notify the parents.
So then we would want that reporting it to CPS as well, because that adds to your documentation.
Yeah,
Even though
I
they
think-
may not even take it because it's the potential of harm,
right.
just having contacted them, is that something that?
I think so if a child said to you, and you know better than I, like if a
Right.
child said to you, my father would kill me. Would you go down the road of, has he hit you before, or,
Mhm.
and have that discussion?
Yeah.
And then if that child does articulate. Some prior abuse. I don't know.
Yeah.
What, it sounds like then the mandatory, reporting obligation is triggered.
Yeah, I don't want to but what you just said, but we actually train people, you don't investigate.
Oh, right, right.
Once the thing has been
Yeah,
said,
that's fair.
where you're not asking all the follow-up questions, you're letting CPS to do that.
You're right, but so you think at that point, like I said, you know better than I,
Yeah.
then you have a reasonable suspicion
Right.
of abuse, if the child makes a statement like that, that would typically trigger mandatory reporting.
Right.
You're right, you're not supposed to investigate. It's like ring the fire alarm, don't
Yeah,
investigate. Other than-
yeah. Thank
Actually, it triggers our first substance protocol. At that point,
Hmm.
we would be contacting the police, based on the information. Yeah.
Mhm.
I had the same concerns as Dr. Flashman. So I'm still gonna say congratulations.
Thank you.
In the case that Dr. Flashman just mentioned, it was a very direct, like my father's gonna kill me, right? Or my parents gonna kill me. But what if they're like, I'm in fear of, like, they're gonna kick me out of the house, or like a different harm, right? That is not direct, like,
Mhm.
like the extreme. Like, what would we do in those cases? Because I feel like we might see more cases in that direction, right? Where it's like, I fear of harm, or I fear of X or Y, maybe not direct violence, but like, and I'm guessing a lot of educators, including teachers and principals, in those cases would want to protect the student no matter what still. But then what I'm hearing say is that it could be a violation of the law. So what would we do in those cases if it's not a, direct, like, my life is in danger?
Mhm. What if it's, I mean, and so if it's not something that's gonna trigger, there is physical neglect or abuse that would trigger mandatory reporting, then maybe there is further discussion and you want to just, why do you think that? And if the site administrator or an administrator is gonna make a decision and say, I have concerns here about abuse, I think just once again, documenting and being able to articulate it. If one day you're filling out a declaration when the parents are bringing action because they were not informed. And then, creating that documentation and articulating the concerns you had for the neglect or abuse of the child.
Yeah, so you've been discussing affirmative obligation. Is it held to the same standard as mandated reporting? In the sense that, if I'm a mandated reporter and I do not disclose what I know to be true. What repercussions must the district hold me accountable to if they find that I didn't meet that obligation?
If you're talking about the obligation to disclose to the parent, well, for right now, it's a question as to whether there's an affirmative obligation to notify the parents. I would say right now, the state of the law is there is not such. Until you hear a court say that there is, I would not say that there is an affirmative obligation to notify the parents unless they inquire.
Yeah.
Then you have to tell them. And unless you can really articulate, are able to articulate facts that would support, I have a concern about abuse here.
What if we have teachers that just refuse, and we have very active social justice, right? Like, not just teachers, but also union, right? So what if in those cases, right, where a parent does ask, like, there's just refusal, would it just be handled disciplinary? Like, is there a way for us to protect teachers in those cases? So I think we can all empathize, right, with that?
Yeah.
So
So. I think that, once this is part of the district's process and guidance of parents said, I don't want you to, identify, I don't want you to refer to my child by their preferred pronouns and their name, and the teacher insists, or the parent says, I want to be noted, what are you calling my child in school? I want to know because I'm hearing conflicting things, and the teacher say misrepresents that, could potentially be that is a disciplinary offense or potential disciplinary offense. Now, with that said, this is gonna be an issue that's gonna come up statewide,
Yeah.
right?
yeah.
And, you'll probably see a map in California as to where you're gonna see instances of this happening. And there's a lot going on right now, or in a lot of different issues going on nationwide and in California where there are calls for teacher discipline, and the district's just like the district in the border. I'm not gonna discipline a teacher over that. So this is one of those scenarios. I think they are potentially eligible for discipline or letter of reprimand or counseling or whatever. But I know that is, just the reality is, like a lot of other issues going on right now. If that doesn't happen and a parent files a complaint, I think it may fall to where CDE is, right? And I'll give you an example. allegations of anti-Semitism, right, in school districts in California. CDE has taken what I would say, based on the legislature, a very aggressive stance now in regard to dealing with anti-Semitism that I don't think was there 3 years ago, right? And so it depends on how this plays out. If people are filing complaints against employees, filing lawsuits, filing OCR complaints, filing, appeals to CDE, following a UCP complaint or a complaint against an employee, it depends on where CDE is gonna evolve on this, I think.
On a technical level, Power School is set to send letters with students' preferred name, and it was actually when I was a principal, parents got really upset, like, hey, this is a student record and I'm getting it with a preferred, not a legal name. And so are we now needing to make sure that all our settings are setting them to send anything home under a legal name?
I don't think that that's what the law is saying. I think it's just that parents have to be informed if that is what you're identifying the child at
So
school.
like right now, a kid would walk into the office and say, my preferred name is this, and have a conversation with an administrator. And we would change the name in Power School with or without the parent's consent.
Uh-huh.
So now that conversation, what I'm hearing would look like, okay, but in order to make this change, I have to make sure your parent is informed.
Yeah, that's a really good question, because you're supposed to be consistent, right, in keeping
Mhm.
parents informed. So what that's gonna look like in Power School or in literature at home. I think we're gonna run into the scenario where you probably are just gonna keep doing what you're doing, and then if the parent inquires, but I think that is a fact scenario, I think is gonna run into problems with parents who are gonna say it was misrepresented, like I've been receiving, emails where I've been receiving correspondence about Charlie from my daughter Charlene, and I have, or I'm sorry, I've been receiving, Charlene for, I didn't realize that they were being called Charlie at school, and the fact that the district kept sending me correspondence referring to Charlene at home, Charlene in the correspondence I was receiving misrepresented to me. I think we're gonna run into that problem.
Okay, the other thing
So,
is,
so I guess the belt and suspenders approach is make sure it's consistent with whatever
Right.
you're calling it now, but again, I don't know that that is necessary. I think you can say that's not our obligation at this point, because that's what we vote in the legal name when we communicate with the parents.
it's the preferred name on the parent communication. So it does out the students, right?
Yeah,
But we don't ask the parent permission. So I think that's the
and then if the
inconsistency.
parent comes back and says, I want you to refer to, you wrote it as Charlene, I want you to call Charlene Charlie.
Now we need to
Now you
delete
need
that.
to go back to Charlie.
The other piece is just thinking of like immediate next steps. I imagine we have many principals right now who have kids who show up to school and go to the bathroom and change clothes. Do they need to now call those students in and have this conversation proactively this spring?
I mean, so do these students have 1266 gender transition plan?
It's a good question. I don't know. I know that, I haven't been a principal in a few years, but in my head, I know who those kids were at my school. And some of them, the parent did not know, right? So we had some cases where the parent came in with the child and said, my child is going through this transition, and it was very supportive. We had other cases where the kid showed up and changed clothes in the bathroom and told teachers, my mom doesn't know.
Yeah. And so what we're generally advising is if kids have a gender support plan, you call them in, have the discussion about this is the new law, and just inform them of the new law regarding, we're not gonna be able to keep this confidential. My thought is, and the administrators on the ground would know better than I, probably a good idea to notify those students who are also, even if they don't have a formal gender support plan, that you make them aware of what the law says, so they're not. I mean, things have changed, and so maybe they should be made aware of that.
But what I heard you say is that, as of right now, we don't need to change any of our policies. And we're kind of just waiting to see what circuit,
What the Ninth Circuit's.
Ninth Circuit says, so.
And then we'll be making some determinations. I don't think the CSBA or my firm necessarily has like, this is what will change, like, what, it's gonna, like it takes CSBA for their model policies and takes us, like, we'll have to think about, are there any required changes in the board policies and ARs? I suspect there may be, you know.
Okay, did you have one more, sorry?
Yeah, should the district or can the district talk about this law with students now in any trainings?
Yeah, I think that it would be, in regard to any trainings, I think it would be good to notify students. Whether they have a gender support plan or not, just notifying students if it comes up, or if it is the appropriate context. To notify them of the change in this law, because I think there are, you know, it's a sea change from what students have been hearing over the last, 10 years, 12 years. Does that answer your question?
Yeah,
I was actually thinking in that same vein that most of our secondary schools have a QSA or GSA or some sort of student
Yeah.
advocacy group for LGBTQI students, and that would be a good opportunity for school leaders to work with those groups, because they also, oftentimes, there is a sub-community at schools that is not as outwardly communicative with administration.
Yeah.
Right? But that those other students in that community are aware of and can help spread word and can help share. So I think that it's important that not just the ones that come to the principal Sigler and say, hey, can I go change? But also the ones who are doing all of this as best as they can in the shadows, because they don't feel necessarily that the school administration is going to keep them safe as well.
Good
So-
idea. I also, as we're talking about this, I want to talk about the fine dance that's being done with AB 1955, which was. The governor was touting this, saying, we never told students that, or we never told parents. And it was never the law that we weren't going to disclose their children's gender identification to them, or gender incongruence to them. That is what CB was saying. But what the law that they passed, that the California legislature passed, was that you can't require teachers to inform parents of the gender incongruence, right? But now, so the law did not, or the courts did not undo AB 1955, but I do want to give an exception. If the parent inquires, then the teacher is obligated to notify, right? If the Ninth Circuit also determines there is an affirmative obligation to notify parents of this, then AB 1955 would go out the window. Right now, AB 1955 is still in place. You are not obligated to. The teacher is not obligated to tell a parent of the gender dysmorphia, gender incongruence. Unless the parent asks. And then you can't misrepresent anything, and you have to disclose it.
So, I mean, I do think that, my concern about principals starting to talk to students, though, is the inconsistency that it could create by sites, right? And how strongly does a principal go about it, right, versus another, who might just ignore it, right? So I think that I would love to, for cabinet to kind of think through, like, what would be the best approach to talk to principals about it, right? And then do a training. I think that sounds like there's a lot of details that we still don't know. So waiting for next year might be the best, next school year might be the best approach. Especially as we have new school leaders potentially, so. For now, we're just waiting to see what happens, right? And we're not proactively doing
Yeah,
it.
but I would say that for now, the law is, or
The law, right?
The court
Right.
ruling, right? The
Right.
court ruling is,
Right.
if a parent asks, you have to tell them. And so, you're raising a really great fact that judges don't necessarily think about, legislators don't think about when they pass any of this, like,
never.
what is the
Never.
practical impact on kids? And what is, right, it's like, so what does this look like on the ground? And what's the startled by that man post is, Um, I'm very familiar with this too. So, so on the ground, what does this look like? But you do have kids who have an expectation that this is gonna be kept confidential because of what the state of the law has been for the past 12 years. So, how you wanna inform them, when you wanna inform them, excellent question. But that's something that the judge is not thinking about.
And a student might have been told, we're gonna keep you safe, we're gonna protect you, we're gonna also keep your secret, right?
Yeah.
For lack of a better word, so that
Absolutely.
changing right now, I think is also dangerous.
I will, there will be parents out there who expect that to be in place immediately. That
Right.
If I asked, I need to know now.
Yep.
And they're not gonna wait for their student to be informed of the change of the law.
That's my biggest fear. It's those kids who are promised confidence.
Yeah. Okay, any last thoughts?
Just some last thoughts is that I do think that, your site leaders need to be told something quickly.
Yeah.
That this is the law and that there's whatever the minimum, I mean, if I'm reading this district correctly and probably the board, even though I'm not speaking for anybody, it's probably gonna be a light touch. We're probably gonna be a light touch district as opposed to some other places, but they do need to know that exactly what they have to do now. And there will need to be a plan for ongoing training as it evolves, so everybody will have to know what they're doing on the ground, what they can, what they can't.
Yes.
And it's gonna evolve, so there has to be training
That happens.
every year.
We have a couple of places where we want to make sure that this guidance is in place, and that would be in our parent-student handbook as well as our principal
Yeah.
handbook.
And then the other thing is that, is there an objection process?
Bless you.
Or how does the parent, like, is there an objection? I wanna know or do parents have to inform that I wanna know everything, or not, like I said, just some of those fine details are gonna need to be thought out, because the courts never think about how it translates to the ground, they're very idealistic.
And I expect that's a really good point, that you are gonna, you may be receiving some letters from parents or emails from parents referencing the Mahmood decision and saying, I have the right to be informed immediately right now, and taking a very expansive view of what the Mahmood decision said. Which unfortunately with Mahmood, reading the tea leaves, I think down the road, Mahmood is going to become, with the Supreme Court, I think Mahmood is going to be widely expanded in
Oh, yeah,
regard to
For sure.
parents' rights.
I think we should, as a district, we should prepare for like the most extreme parent reactions, because though, like you said, we are gonna be a light touch district, the overall consensus in our district is one that is much more progressive and accepting. We definitely have pockets, and there definitely will be, individual parents and families and things like this that will press this to the fullest extent. So we should be prepared for all outcomes.
And I've already had a parent from, I think, the Hercules area reach out to me and say, hey, like, what's changing in the district when it comes to this decision? So it's already unfortunate. I mean, maybe 1 out of 30,000, but unfortunately, it's still gonna happen, right? And there'll be more. And lastly, I wanted to recommend that Dr. Greenwood, maybe HR can also have just a light conversation with our union leaders, just about this decision could also lead to this request. And unfortunately, like, this is what the law says that employees have to follow, right? So just so that everybody is on the same page too about our possible actions right now. Okay, any last additional thoughts?
The last thing just for
Sorry.
Ed, is this when you said CSBA published some good guidance, was it the email the
You-
Supreme Court?
You
strengthened?
distributed that, yeah.
Okay,
that's
yeah,
right.
yeah,
So-
okay. So I think everybody should get this then, and I could just leave it for everybody to get copies or whatever.
It's- Usually when attorneys write stuff, even my client had a client who's briefed on this as well, so I'll send on to you all. But attorneys tend to get very verbose about this, but, so there are some real nuggets in that one, and in our news brief about like what to take away.
Thank you. And do we have any public comment on this item?
Yes.
Maria Resendez, please unmute yourself.
Yes, good morning, everyone. Um, I think I just have a couple of suggestions for the board. One of the things that we really have to be, I think we have to be as a district very proactive in the communication that goes out to families. One of the biggest complaints, and I can tell you that I got dozens of phone calls when the progressive flag was set up in our school sites. So without the proper information or communication about it, right? So now that this law is probably going to be coming our way, I think we really have to be proactive about the communication to families, not only about what is happening, but also about being general in terms of this is what's happening in our district and not leave it up to our administrators to interpret what is happening, because I think it really depended on how the communication was flowing down to families, that families took that interpretation of the new things happening in our district. So just a thought.
Thank you so much for that comment. Are there any additions?
No, there's no more public comment.
Okay, great. Well, let's now move on to our other few hundred policies. We're doing great on time, y'all. 1 hour on one. Okay, Ms. Sigler, am I passing it to you? Are you gonna walk us through?
I am happy to walk us through.
Okay.
As we keep adjusting our procedure here. So I'll just say out loud my thinking. If we go in order of policy, it'll bucket it, the zeros, 1000s, 2000s by the people who worked on the policy. And so then we can call them up to in group, say, hey, these ones should really just go in a group and tell us if they have any for discussion. Is that amenable to the team?
Yeah, that sounds great.
Great. And so the first one, and we'll start with mandated and go back to conditional if that's also okay.
Yeah, absolutely.
So the first one, Jose, is non-discrimination. Do we need discussion on this or do you recommend it to move forward?
You can move forward. It was minimal.
Ms. Sigler, is there any way that you could share your screen if that document is?
Yeah, so
Public
I'm just
facing.
looking at a list of the policies. Let me
Okay.
see if I can share screen on this Zoom.
Thank you, thank you.
Yeah, it's actually quite good.
Who's gonna be the,
I'm lost.
you're doing too many things?
Yeah.
Okay.
Looking for Zoom. Oh,
Of course, I was like, why do we need that? We don't need that. Don't listen to me.
Question about this policy. We're talking about 0410, right?
And
Yeah.
several windows to work.
She's sharing her screen.
Is it 0410? 0410?
Could you repeat that?
0410.
0410, yeah, my question, particularly about this one was, I see it listed twice. So this is one of the CSAs policies as well at the bottom, and I look here and it says keep CSBA with edits. But then when I go down to the bottom to the CSAs one, it says use district. So I'm
Which-
just curious.
which
to be
document are you looking at?
consistent. So if you look at what looks like, yeah, so they're listed twice, right? So I wonder if we could sort this document by policy number.
Mhm.
There's an inconsistency, it seems like, between what I hear you saying and what I see the directive being, unless I'm missing something.
Here as that, but then down further, it's listed again.
Yeah. Yeah. Does that make sense?
Yeah.
Am I seeing? And I apologize, I wasn't at cabinet yesterday, so this was already discussed, I may have missed it.
So I would defer to you. You know, this is under CSAs, but it's really under your, more so under your office. So if we had two differing,
Well, your office worked on it.
we did.
Okay, so that policy's already gone to the board for first read. We're just waiting for a second read.
With our edits, with the work that we did. Okay.
Yeah, it went for a first reason.
That's what I thought, yeah.
Do any of the edits that are currently on there,
The one we're looking at.
alter the edits that you've already, provided?
Spreadsheet.
Let me pull it up.
Just so you.
No, we haven't, but we haven't edited since we brought it forward the last time.
Because I don't know if CSBA took into account the current one that you're working on.
The last modification I see is 10/23/25.
Yeah, so that's the edits you guys made.
Correct.
So it's just a directive wasn't the correct one. I'm assuming at this point, we're just gonna keep the district and bringing this forward back to the board for second read. And then once CSBA does the whole haul of all the policies, they're just gonna use the one that we just currently updated.
Yeah, in that case, I would say keep district, because then that will keep your, current policy you worked on, and I know we worked on that, because we provided additional
Right.
language. So I would say keep,
Okay.
we can change it to just say keep district.
Okay.
Rosa, you're checking the notes in the spreadsheet.
I'm
And I'll just.
trying not to sharing right now, yeah.
Okay, I can move this one. I just, I don't want to mess with your system.
We're good. Okay, so we're moving that forward. Yeah.
So I'm just moving the X to use district and we're moving it forward. Okay, and then Guthrie, the next one is conditional, so I'm moving on to the uniform complaint procedures, board policy and AR, Jose.
The number,
1312.3. Do those need review or are you recommending those to move forward?
I'm recommending for those that move forward.
oh, okay,
Might be faster.
okay, I had some questions on that one.
Okay, great. So,
So, let me see here. Okay, so the first is that there's a board policy and an administrative regulation. So once again, as we discussed before, some of them are showing up on the list and some of them are not. So if, I think they should be reviewed together. And that, I mean, and if CSBA recommends, an AR, which they do, I think that we should look at them. They're pretty basic, but they add more flavor to what the board policy has, and so in general, I'm favorable about including them and looking at them. So that's just one statement. The other thing I have on 1312.2 is this was brought to me by the constituent. We have a form, which is complaints concerning district personnel, and at the top of the form, it says preliminary steps in 1312.1 must be followed prior to submitting this form. And when I read 1312.2, I really do not know what to do with this, and this constituent is correct. I don't know how to interpret this before filling out this form. So I don't know if the form needs to be changed or the policy needs to be changed, but they are not congruent. And you don't know what to do after reading the policy. So my recommendation is that I think the form needs the work and not the policy, but whoever handles that.
That's for 1312.1.
Yeah, it's a different one.
The other thing I have is that there's a lot of language in this that talks about,
And then the policy that you brought this up, was that on the 1312.1 or 1312.3?
it was.
This is the point one, which
Yes.
is district employee complaints versus uniform complaints on point
They're
three.
different, so that one coordinates with the 1312.1.
Okay, I'll be quiet then. Never mind. All right, so you know what's coming next.
so are we ready?
But
Oh, sorry.
also, I'm sorry, 1312.1 also has an AR and a BP. In CSBA.
But
Yes.
they're not mandated. They're not marked as an M.
But if one is mandated and one is not, would it just make sense to do them together though?
So 13.12.1 and the EP and AR are not listed as mandated, the 13.12.3 is on.
But if one is mandated, it doesn't make sense to review that at the same time, just to make sure that they're.
Well, they're gonna be reviewing them all, right? Well, that big,
From what
The
I'm hearing
big
is
change.
13.12.1 is not on this mandated list, but you wanna review it.
Yeah, I'm just asking, like, we will just not look at the AR at the same time? Even though the policy is mandated?
Well, on this one, I don't see that the BP is mandated either.
not 13.12.1.
Not 13.12.1.
Okay,
Those aren't mandated, it's mandated when you get to 13.12.1.
But you guys will review it eventually, right?
We will get to it.
In the
for
next
big-
couple of months,
for
you guys
the-
will
That's
review
in
it.
that big group that we're
Okay.
doing.
So
Yeah.
the point one, the complaints against personnel, like that's just a CSBA thing that they've given process to deal with. The 13.12.3, the UCP, that is mandated that you have a policy and a regulation and a process. In the state regulations, it says that a district has to have that. There's no obligation to have a complaint against employees process.
okay. Okay, thank you, Jen.
Are we landing on okay to move forward?
Yes,
Wonderful,
I don't have anything.
wonderful. Okay, the Williams complaint procedure, Catherine. Was this under you or Jeff? 13.12.4.
Oh, it wasn't, yeah, we're just keeping CSBA.
Okay. Are we okay with moving forward?
So my only other question is that they have exhibits also, and CSBA has exhibits that, is that any interest in those or not, or do they come later?
I think they
That you
come
may-
later.
Later,
Yeah, because it's for us to look at, but it's not mandated that we look at it right
Okay.
now. But we will have it on the list to look at.
And use of school facilities, Jeff.
And previously, I haven't seen some of the exhibit documents that CSB has provided for the district to use. So it can be up to the district's decision whether we use exhibits or not. Yeah.
But it will be looked at, it will be reviewed, because we have to make a directive at some point. When we do the whole manual,
okay.
we have to say if we're gonna use it or.
Yeah, I think that's what I want to
Yeah.
hear. I saw it. I agree with it or I don't agree with it. We're gonna use it or we're not gonna use it. It's just, because
Yeah,
that's it. But sometimes I'm not sure that you guys know. Feels like, maybe I'm just,
we have the whole list, but then we focused on the big ones because we have to get through those for this. But we try to look at them together if they, so they'll come at a later time if there are. Gaps or. Yeah.
Okay, so 13:30. We're keeping CSBA's edits there. The only thing we're changing is there was option 1, option 2, or option 3. We're leaning, or we have it in here as option 1. I don't know if I want to talk about those options.
Could you show us the option, sorry? Can you
Yeah,
show us to us, yeah,
like share my screen.
yeah. Sorry, we might have to go back and forth every time.
Or was this
To show that.
cord.
It's a-
So, option 1 is about, using school facilities or grounds not resulting in an expense to the district. So charging what it costs us to do facilities use. Option 2 is about not charging nonprofit organizations. And then option 3 is, no charge to school-related organizations. Typically, we just charge anybody that wants to rent use facilities, but if we want to not charge nonprofits or not charge school-related organizations, we can go with the option 2 or 3.
And right now, what we do is that we charge all those groups, but with a smaller fee, correct?
It's just the fee for the custodian to come and open the facilities or materials and supplies, depending on what facility they're renting.
So if we were to choose option 2, it would be at a charge for the district because we would still have to pay the custodian.
Yeah,
And then, okay.
Yeah.
So if I understand correctly, you're covering your base cost, but you're not making a profit.
Correct, there's no
Okay.
profit in this, yes.
Got it.
But the option 2 and 3 is just to charge specific types of groups less if you wanted to give them a discount. But it would.
We're not in a position.
Yeah,
to do that.
okay, alright, so we're just thinking with option 1 where we charge everybody the flat rate.
And what's a school related organization? Is that like a club? Like?
Your own athletic teams,
Oh, I see.
you know, so this one gets a little sticky, right? Do we make the basketball team have custodial when we open it up on Saturday?
And charge ourselves.
And charge ourselves.
All right.
I think right now that is the practice.
Oh, it is.
When I was a principal, I fought against it a lot. I was like, this is regular wear and tear of the facility. So that probably doesn't have to live in policy, though. That's working with our labor groups on practice and how we apply, because your basketball team practicing in the gym is different than having a play in the theater with 400 people in it.
So right now, if the basketball team at the answer wants to have a practice on Saturday, it's the district charges the site for their own team to use their gym.
So what most sites do is like cluster, right? There's a window from 9 to 12 AM. Anyone who wants to practice, come in this window. That's when the site's open.
Wow, okay. And Mr. Carter, and you can tell me this off the top of your head, but do you know how much total we charge a year for our own schools to use their facilities in that way?
Not broken out that way, but I
No.
can.
I mean, I think that it would be interesting just because. We're, like trustee Reckler said, we're not at a place financially where we can do really almost anything, but it does seem weird to charge our own sites, right, for the use of their own facilities, although I understand obviously the issue with the custodian. But-
Yeah, it's more about making sure that they book it on Facilitron, so we know it's rented out, so nobody else can rent it.
And once again, I think that can live in practice and procedure. I think in terms of a policy, this is okay for policy.
Okay, okay, well, I'm okay with that, but I would love to get that figure if that's possible. Sorry, go ahead, trustee. Rickler.
Okay, so the board did pass an updated 1330 a few months back, and it had language about using the school facilities for immigration. That seems to have been omitted, and so I have it printed for you. The superintendent or the designee may prohibit the use of school facilities when blah, 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 immigration. So I'll just hand that off to you, and it's the highlighted piece right there. So that should get back in. No, because the adopted one does not seem to be reflected in the module.
Okay, well then, we can bring this back for edits, if we wanna add this section.
So that was previously approved. I think you should just stick it in and move it forward.
So
I think
I-
it needs to come back.
We'll do
I
that.
put in the notes on here, Jeff, just to add the edits, so we can say move forward, but add the edits.
Okay, we'll add this block to the existing one.
Great, and then we know the next policy bears some discussion. It's the response to immigration enforcement.
Oh, yeah.
Also,
we're not going in order with this.
I am going in order.
Oh. Thought we were going by what probably were.
Don't listen to me. I'm just a troublemaker.
We found a hybrid, but our student booker over
Right.
there is trying to get off the hot seat.
Always good on the hot seat. So. Let me just turn on my.
Also, could the spreadsheet be shared on Zoom, please?
Oh, yeah,
for the
back
public?
up. Ms. Sigler, if you don't mind.
Yeah,
And Mr. Booker, if you need to share the policy, would you like to, so we can put it on the screen too? So I want to make sure the public can see what we're talking.
yeah, and that may make more sense to let Mr. Booker share screen with the policy that we're looking at. I can do the screen share for you.
Can you go to the board policy?
Yeah.
1545?
Yep, I'm pulling it up.
All right, good morning, everyone. So we have presented before you is board policy 1445. It's our response to immigration enforcement. This policy had been under 5145.13. CSBA's recommendation was that the policy be molded into 1445 and 5145.13 be deleted. So we did that. And we incorporated, so previously what we had in 5145.13, we had all the information pertaining to our response to immigration enforcement. And it included what would normally be an AR. So we never adopted an AR for our district. So what we did, we took the recommendation of CSBA. We also sent this to Ed Sklar, who reviewed the policy and said that the CSBA model policy and AR needs no modification. So other than changing the title at the beginning to West Contra Costa Unified, we went with the CSBA board policy and the AR. So essentially what we did is we took from our old policy that we had approved in 2025, we took out all of the AR information and put it in the actual AR. So we now have an AR that we are presenting as well as the board policy. In terms of the, and this is a policy that is mandated, that is, should be done by March 1st. We had the information ready to go. It just needs to go to the board for final approval. And as far as the AR goes, any information that we had in 5145 is in the AR now. Are there any questions? Yes.
So I have two. The first one is that in 5145.2, we had built in a training module,
Yes.
or it, and I'm not sure I caught that in 1445. That we did have a yearly training to bring everybody up to date, especially about warrants. I
In
think
the work policy or the AR?
in 5145.2.
You mean in our previous?
Yeah. So I'm not sure I see it here. Number one, do we still think that's important? I personally do. And then number two, if it doesn't live in this AR, where does it live? It's in Keenan, but,
Yeah, it is, the training component is in 1445 of the AR. Let me just go to it.
and then we can just note this, and if we can't find it right now, it could get written up for later. If people think it's important that there's a yearly training available, or people are trained on immigration enforcement.
I do, and we actually have it in our communication that goes out to our staff, so, I believe it's in here, but once I find it, I will let you know.
Okay, and then the other question I have is, it was my understanding that immigration, I mean, of course, we've seen Minneapolis, but they're supposed to stay in a public space, but this policy says if they're gonna go, you let them go and you don't stop them. Or this regulation says, you don't impede them. It feels to me beyond the public space. Am I reading that correctly?
Ed, did you wanna,
Yeah, what's the language that you're reading there?
and trustee Reckler, you're looking at the AR, correct?
Hmm.
Yes.
Is it don't impede?
Yeah,
Yeah, I mean, we don't participate with them. If they are coming on board and they're saying, move out of my way, I need access to that, I'm gonna take access to those files. As we tell, don't physically restrain or impede law enforcement officers, even ICE, from, don't interfere with the guys with the guns. It's just, it's like, that is, there's this crossover of not participating and impeding. If they are just coming on without a warrant and they are saying, move out of my way, or give me those and grabbing files, then document everything you see, let them do it, let them move forward and do it. But I'm advising, well, we've been advising folks, do not physically impede these folks from moving forward.
okay,
And-
I think that's really important that people know that's on sites.
In,
And that could be a part of the training, actually.
in our communication that we put out to staff, we did tell them not to impede, to get the information, and document anything that is going on, but not to impede, because we don't want them in harm's way.
And also even record it. Use the phone and record what they're doing. That's what we're saying in the training, not necessarily in the policy or the AR, but yeah, it's sound advice. When I do this, I've done this training a lot, the immigration enforcement training. And the response in the area, the question I always get is, at what point am I supposed to physically impede the officer? And it's like, don't physically impede the officer.
But normally they should stay in the public.
Normally
place,
without a
like the-
warrant, without a warrant without a warrant or a judicial order, they are supposed to stay in the public space. They don't have any more right to be on campus, to be in those spaces without a warrant or a court order or exigent circumstances. They're chasing somebody onto campus, than any other member of the public.
But
And
where
many
does,
times what they will do is they will try to use the guise of an administrative warrant to.
Oh, yeah, I know.
And that's why we do training with regard to administrative and judicial warrants. But what they should be doing and what they actually do are two different things in terms of ICE enforcement. So,
It's an excellent point, which is why they changed the law this year.
yeah.
To say, the California legislature to say, only judicial warrants, only judicial orders, these administrative warrants. Which are just signed by the supervisors at ICE, and that those don't meet Fourth Amendment standards. For a probable cause to be lawfully enforced.
And trustee Reckler, in our training that we give our staff, we show the difference between the two. And we actually show the actual documents in the training.
Right, we have additional language though, which is if this were to happen, the superintendent gets contacted immediately, so. I feel like there are many stopgaps in the process, but still people should know. As much as possible.
I have a question about just where the public space ends. Is it at the sidewalk? Is it at the front door? Is it the front off, like where, and many of our campuses, the fence is, 20 feet in from the sidewalk, so there's a bunch of open space that is. On school campus, but is easily accessible. So where does that space end?
The space is where would any member of the public be able to walk up, and usually it would be just into the office.
Yeah. for the office, yeah.
And have communication with the school employee. Administrator. So they're allowed in the building, because any member of the public's allowed in the building, and the expectation is they're gonna come to the office,
Got it.
sign in, state their business. Law enforcement is allowed to do that and obligated to do that.
Sure.
Actually, in the board policy is where it talks about training.
It does, okay.
Yeah.
Thank you.
So the superintendent designee shall develop procedures for and may provide training to staff on interactions with an officer or employee that need to see
Great,
conducting immigration enforcement, and it lists the
Thank you
different
for that.
things.
perfect, okay.
I did have a question. LA just recently passed a policy that they're not gonna contract with
Yeah.
anybody who has a relationship with ICE. Did they put that into their policy or is it just a resolution? How do they do that? Do you know, Mr. Scott?
I can't recall what LA, I did hear that that was at LAUC. They may have put that into their policy. Now, whether it can be challenged lawfully, I don't know.
Right.
As lawful, I don't know. My understanding was that it was being put into the policy.
I mean, I would be interested in adding that, but it definitely would have get to be legal language, not something I create on the fly. So is that something could you look for that for us?
I can definitely take a look at that because I know that that question was going around my firm and may have been. Yeah, that question was going around my firm, and so I can look at where we landed on that, to where the nuance may be, and maybe some stronger legal language that in.
Okay, thank you.
And I'll confirm that it was actually in the policy as opposed to.
Thought it was a resolution.
Yeah, but I'm not sure if they put it into their policy.
Right, okay, thank you, and that might also affect, I think, another policy. So if you could, yeah, if you were looking at that and also letting us know which policy would have to be changed in order for us to add language like that. I'd appreciate that.
Are we comfortable moving this for a first read as it is?
Unless Mr. Escolar has language that he would recommend that we add to it.
Okay, great, so I'll
With
just.
regard to LA.
Yeah.
Okay. Just put a note there.
Thank you.
And the next are grouped, federal grants, impact aid, transportation fees, bids, lease contracts. There's several. Some of these are conditional and some are mandate, but Jeff has all of them marked as keep CSBA. So I don't know, Jeff, if this is something you want to speak to and we could just move all of those at one time.
Yeah, I was gonna say all the way down to,
Emergencies. and
all those are
equipment.
just keep language. So most of those were recently adopted and we're not changing anything from the CSBA language.
Okay, so it's 3230 and what else?
All the way to 3513.3 that we're saying, let's just keep on the CSPA.
Okay, so I had some questions. So let me see here.
For 3230.
On. Are we up to these spec contracts? Is that in this group?
I guess just talking about 3230 through 3250. Or is that included? Because there's one bolded, the bids one.
The bids one's mandatory, but we've adopted CSB language last year, so there's no changes.
Yeah.
But it's mandatory, so we're discussing it, but there's no language changes at all.
Got it.
Yeah.
But the bulk you're referring to, so that it's just then 3230 through 3513.
Mhm.
Okay.
Yes.
Those are all keep CSB.
The only thing I have on leaseback contracts is if our facilities attorney or Bob Huffington Henderson, if I have the name correctly, if they had anything to add on that. I don't know if they need to, but it's just a question I had.
If you want me to reach out, we did not. We took CSBA's message.
Okay, do you think they need to? I mean, did anything in that spark you to say we need the,
No, it's
Okay.
typical practice.
okay, that's all I have.
And so we will go back to Mr. Booker for emergencies and disaster preparedness. 3516.
Can you place it on the screen?
Yeah. And you did say keep CSBA, so do we need to discuss or do you just want to keep CSBA?
No, he's. Yes,
Yeah, so were there any questions from the group?
Yes,
And everything that is in the current policy, we currently do.
so. Okay, so I had some questions on this on, is there a schedule or a timeline that they need to be approved? Is there like a legally required schedule or timeline? And is this different than a safety plan? Or is it-
Works in coordination with the safety.
Okay. And,
And as far as the date goes, it was March 1st.
and then do they have to go on a time, like, do they need to be reviewed?
Annually.
It has to be
Yes.
reviewed, all right, so it's an annual, I don't know if I caught that. And then is all of this approved or run through the site council?
The emergency, no, so the comprehensive site safety plans are through the site council, but the emergency plan is not.
Does not,
No.
okay. Okay, that was my only question on that. I won't have to ask.
Anything else before I click the magic button? All right, I'm having fun clicking the button, just so you know. Catherine's a little bit jealous. She likes to do the chat. All right, Guthrie Transportation for Students with Disabilities. Do we need discussion? You have used district.
Yep, district and CSBA are identical on this one, so.
Wonderful. Any questions?
Yeah. Thank you.
Right. Now there's several conditional ones. If it's all right, I will go past for you. Into the next several mandated are under Mr. Espinosa from 4020 through 4033. All of which he has said keep CSBA with edits except for the lactation policy, use district, which we recently passed. Are we comfortable asking questions about these in a group?
For the 4020 wouldn't be our office. 4020 would be sometime.
I think I did that one,
Okay.
actually. It may have been you, Sylvia, but there were several somehow that ended on mine that I did, but we were very close to CSBA. And that is why we clicked keep CSBA. There's minor updates in language.
And then the only comment I wanted to make about 4030 was that it references, triple coded policies. So since we have Ed here, I wanted to discuss, is triple coded policy necessary? Or can we just do one policy, moving forward?
Yeah, I think that you can't, so triple coding, you mean it goes across the employment policies as in classified, certificated and administrative, yeah. There's nothing that obligates anybody to do any of these things, right? And so, in some, my understanding is some will have all three of the policies, when you click on them, they'll all click up to the same policy on whatever the software is that provides the policy. So you can do it whatever's easiest for the district, just making sure that it clarifies, we're talking about all categories of employees. Does that answer your question?
Yes. So,
And the other thing is, there may be some slight language, right, and not, I don't believe there is in 4030 or in like the Title IX regulations or the Title IX regulations. I think those are all the same, but there may be some that have slight variations, so I can't say like triple coding across the board is.
so sometimes it doesn't mirror exactly,
Sometimes it may not mirror exactly, yeah.
but if it does, then would the district want to just keep one policy or triple code it?
I am less is more, but I think it's important that people realize that there's different classifications of employees. And it applies so that it's just clear, but otherwise I don't believe triplicate is.
Which
Matter
is
of
why,
life or death.
yeah, which is why I think they probably do that in the first place, because they have their set of classified employees, that's certificated and rules for administrators, and they just want people to know there is a set of rules for all three, and even though they're the same.
So it took me years personally to figure that out. I kept asking, why are there three?
Thing.
So,
Okay.
Any other questions or thoughts? All right, so we will move these forward for a first read. Do we need just procedurally, if the lactation accommodation was just approved, does it come anyway in the bundle or we leave it out?
we just did it, and my belief is that it was,
It was this school year. Yeah, so I'm not clicking it, not because we're not doing it, but because it's all good.
Yeah.
All right, and then we will come back to use of technology because it's conditional. Special education staff, Guthrie.
you know,
recommending-
can I just hand Lori something here while we're doing that? So there's,
It's like, it's not his staff, right?
yeah. Here you go.
Oh my God.
Yes.
There is a board-specific policy on artificial intelligence.
Yeah.
Which I just wanted to make sure that you put all of those.
Absolutely, yeah, and I actually, when I was going through both the employee use and student use, I basically went from artificial intelligence and added in anything that would be useful into the employee use of technology, especially, including language about not using any open AI. And if you're unsure about whether or not it's open AI, then you need to speak to the designee.
Okay, so I just wanted to make sure you knew there was that other.
Absolutely, yep.
And then there was a exhibit about some use of technology, which I just handed you.
Yeah, really old.
Yeah, really old, so maybe
Yeah,
that
and
should
those,
be-
I'm actually working on rewriting these right now based on the.
I don't need to know anything else, just want to make sure. I'm back with it.
Again, district and CSBA are aligned here, so I'm sticking with district policy.
Great.
Or, AR, district AR.
Oh, any questions before I click the magic button? Wonderful. All right, evaluation and supervision, I don't see any X's on that. Dr. Greenwood, were you able to update those?
Yes, I'm gonna use this one.
Any questions on those? Okay, wonderful.
Yeah, they seemed identical.
Rosa, will you fix the X's on that, please? Okay, and then if we go down, there's another grouping that are all, Mr. Espinosa, from 4119.11, through, actually is 4136 years as well.
4136?
Yeah.
No, that's not ours.
Okay, so through 411912. And they all said keep CSBA. Are there any questions?
Oh,
Edits. With edits, yes.
yeah, my only comment is that if there are definitions that need to be included. What is sexual harassment? What is discriminatory bullying? What is, like, if any of those need to be added? My recommendation is that this definitions are added, but other than that, nothing.
And yes, for the ones that we did include the definitions because we noticed the CSBA options, they didn't include a lot of definitions, so in order to clarify for students, parents, and the community, we determined that providing definitions would be more helpful.
Thank you.
And I did also want to comment that the AR for the Title IX sexual harassment for 11912 only has an AR, it doesn't have a court policy.
Yeah. So weird.
So non-school employee must be Dr. Greenwood,
What number is that?
4136.
Yeah, because you did that. Go ahead.
I didn't say,
Which one?
yeah, 4136, triple complete, transfer complete. But it's the same as, CSBA. So then we're gonna keep it the district one.
Okay.
All right, And then the next grouping also is for our HR team, 416.1 through 416.2, injury, industrial accident, personal leaves. There's a grouping there.
We're gonna keep the same.
I did have a question on, personal leave. There were like changes to parental leave that happened last year. I know a lot of it has to do with our CBAs, with our unions, but, have we checked if it's aligned to current law? You did, okay, thank you. That was my only question.
So we are cruising right through.
Sorry, Tim. So
Yeah.
you're keeping the district's policy?
Into 4200, 4216, classified personnel probationary permanent status.
We're gonna keep that, it's the same.
Okay, any questions?
It was 4200 AR, is that one of them?
Yes, it's an AR without a board policy.
Oh, yeah, so there's an option, there were options in this policy, I'm assuming we're option one. Just wanted to see if that was true. Second, I can't get it.
Which options were you asking about?
There are options in there. I'm assuming the district is option one. We're not a merit district, are we?
No.
Okay, all right, that's all.
So we'll keep it in the district.
Keeping the district?
And then 4218 dismissal suspension. And then there's 4218.1 is conditional, but I think these all sort of group. What is your recommendation?
Somebody just added
They keep the district, right?
Just
Okay.
got deleted.
I know, who touched the form?
Something got deleted.
Does? Oh, no, mine only, it has to be the person who did it, has to hit the back click.
Who was it? Was it me? I don't think it was me. Is there a way to check the history?
Yes, I think, you can. I don't know how. But
Yeah.
Trying to find the culprit.
Line 54 just got deleted.
I didn't touch it. Sheets. That's why I did this.
Yeah.
Well, we're not doing this to blame anyone.
We're doing it.
We just need to put it back.
We're just putting it down. Ooh, I feel like this is like an annual included.
So was it, or
In the
I know, I'm really worried it was me. Was it me?
No,
Okay, good.
still trying to figure
Oh,
out.
okay.
I know, because I don't see
I
the.
don't see that. You don't see that. I haven't seen it before yet.
Should we just all press redo or
If we should do it one at a time.
Or just restore this version.
Yeah.
Hmm?
There's a lot of, there's 53 changes.
Yeah.
Yeah, there were a lot of changes, so, actually. Current version.
If there was an anonymous.
It's highlighting her name.
Some, okay, came back.
Just hit undo. if it was
Okay.
me.
I'm just trying to, is it back?
Hopefully
It's
it's not
back.
me.
Yeah.
Maybe
Yeah.
it was me.
Yeah.
Sorry.
Don't be sorry, you're fine.
It's okay.
Now it's something.
All right,
Glad it was not.
so 42.18 through 42.18.1,
Sorry, Summer.
yes.
For 42.16, 42.17, and what's the directive on that one? Are we keeping district, keeping CSBA, what are we doing about it? Well, 42.16.
Use district before 216.
Okay.
All right, next three.
4218.
And then we'll just bundle in the 42.18.1 conditional.
Okay.
We can do that.
Oh, okay, well then we won't bundle that in, if it was just the mandated.
Those weren't, that one wasn't completed. 4218.
Okay, so we will move on and bring that back.
4218, I didn't see them in our policy manual. I don't think. I couldn't find 4218 in our manual, so I don't know if that is me or.
On the bench this one.
218.
And Jeff, if we could also draft pulling them for me, just because I'm screenshotting.
Sure.
Thanks. All right, last grouping from our HR team, at least for now, 42.61.1. And then 43.15, what were your, and it says you did option 2 on the personal illness and injury leave.
We're keeping the district.
Keeping the district, any questions on that?
I do. I actually would recommend that you look at CSBA's. It's similar, but it's more descriptive, so.
And if you're keeping option 2, that's from CSBA's options. So it would be with edits.
And keep it against the CSBA. When I keep on options, just.
The CSBA edits.
Okay,
The CSBA with edits.
yeah, and option 2 is what you had written here.
Right.
Yeah, great. Any further questions? All right. Evaluation supervision 43.15.
Use district.
Okay, any questions?
Actually, I recommended that you looked at CSBA because I thought it was more in depth. That's. CSBA just expands more. Sometimes it's informative, my opinion.
Do we want to bring that one back so you have a chance to review? Okay. All right, and now we are into our 5,000s, parent rights and responsibilities. We recommend keep CSBA. The changes were minimal.
I just saw a line get deleted. Was that on purpose?
I don't think it got deleted. I think it just adjusted. Because I put notes in the far right column.
Which one was that? 5020?
Yes. Jeff, do you mind pulling it up on the screen in case trustee Butler has questions?
Yeah, I got it.
Yeah, there's no-
For the AR, I have a lot of comments on that, but I didn't have for the policy. I can see this being a discussion with the board.
Okay, good to know.
Not so much this, but the AR, I think.
Okay. Do you want to say your comments now?
No,
or-
I can, just knowing the people I sit with, I can just see a discussion, that's all.
Okay, thank you.
I don't, none of it bad, I mean, it's not.
The next set's conditional. The admission through the district residency, we are recommending that we bring them back to this committee. We do have edits that we recommend, but in conversation with cabinet yesterday, we'd actually like to work with Mr. Scalar on a couple specific questions that we have, and then bring them back to this committee if that's amenable.
I thought what I read was quite good, actually, and thought that we needed it, so.
Good, I'm glad we feel good about it. There's just a few ed code discrepancies that we're worried about.
For which one?
It's sort of this bundle of admission, district residents,
Oh, okay,
and enrollment. I owe you an email,
okay.
with some specific questions.
I can also see those being a board discussion, so.
Yeah.
just-
Yeah, we just want to make sure we've sort of gotten all the
Yeah.
answers.
So that's coming back.
Yes. And then chronic absence and truancy. Keep CSBA, and LaShante is here and ready for any questions.
Yeah. My comment on that is that I thought the AR was kind of odd but good, because they have a lot of descriptions on what these things are, and I think that's important for parents to know and for the community to know, so I would actually recommend those coming back together, even though one is, required and one is not, but that was my read on that.
Of the absences and
Yeah, because
excuses.
it tells you this is a chronic absenteeism, this is what truant is, this is what, and I think there are a lot of questions about what those terms mean.
Yeah. We can move those together, even though one's conditional, because we did review it as a team.
Yeah, that's all.
Great.
But sometimes I just think they're really helpful to the policy, and if you just pass policy without the underlying, sometimes it's not as complete, that's all.
And the next set are under 5121 through 5123 bundled together, and these are Catherine's.
Yeah, so we've got grades and evaluation of student achievement as keep CSBA with edits, really just tailoring to our context. And then 5123 promotion, acceleration and retention already went to the board for both for the policy as a first read, which we had essentially kept CSBA with some tailored edits based on the conversation we had with governance. We also took the liberty of aligning the AR, which is mandated. And the grades and evaluation of student achievement, the board policy is not mandated, the AR is. So any questions about those?
Let me see what this to. Oh, yeah, I had a question about extra credit.
Mhm.
So. What is your feeling or what do we do with extra credit right now? She's like,
In secondary?
mostly secondary, but other,
I mean, I'll probably tap into summer for some, here, but, I think about, like, there are certain courses, right, honors AP that give you a bump on your GPA. And there are assignments that make up your grades, so, in terms of practice of how we feel about extra credit, I think it's probably dependent on the teacher, but is it widely used for anybody who has a secondary experience?
Yeah, I think it's a carrot. I think that teachers were trying to move away from it when we were doing the grading for equity work and really focusing in when your grade is about your mastery. And I think there is still a small place for this, right? An incentive, bring your parent to back to school night.
Mm.
And I'll make up an assignment that you missed in the grade book. Teachers do things like that to incentivize getting the parent in to talk to them. The school play matches a novel that we read. Go to the school play. I think what gets hard there is if there's anything cost prohibitive, right? We don't want to reward that you can buy something. And so that's where we need to be really mindful. But I think grades should not be made up of extra credit, but when we can do some fair incentives, there's a place for it.
okay.
Any other questions?
I also have another comment, but I was not very good in where this goes. So you'll have to bear with me. There was one line in one policy that said, if you're missing an assignment, is there a time limit on when you can hand things in? Is it forever? Is it up to the teacher? And this was especially, I think it was in the chronic absenteeism policy where it said that you're not denied work, but how long does that go on for? Is it forever or?
And we didn't, so I looked at both, because this sits between mine and Summer's department. Anytime we saw anything regarding time limits for assignments, we went with the least restrictive in order to make sure that we're being as responsive as possible to our student, maybe experiencing homelessness and or challenges that are leading to fluency. I can specifically, but I don't think it was in this one.
Yeah, it was, I didn't.
But it was
I couldn't
somewhere
know.
else, and
Yeah.
it was on Summerside, and we took a look at it
Okay.
specifically, but made the edits to be as open as possible.
Okay. And then in another one, I think it was 5121, but again, I didn't do a very good job here. It says progress reports K-3, but do we do that for more grades now? For
Progress reports are all the way up, and so there is stipulations for what requires a progress report. Some teachers decide to do progress report for all of their students, but if you are at risk of getting an F, or if the student is at risk of retention, teachers must provide it.
Okay, because somewhere in here in one of these, I think it said for K-3, there's no grades, there's only progress reports. And so I was wondering if it applied to more grades.
On 5121, you mean?
I think it was 5121, but now I'm looking at 5121, I can't find it.
Yeah. And this is grades. We're going through it right now, 2 seconds.
While they're looking for that, trustee Reckler, I also lift up that a lot of students in their 504 plans or their IEPs have extended time.
Yeah, that's why I was questioning that. It doesn't say, but maybe it should say.
I missed that.
Or just, I was lifting up that a lot of students in their 504 plans or IEPs have extended time on assignments. Because she was asking about that, it's just relevant to the conversation.
And is that in your policies?
I mean, it's ed code, it doesn't necessarily need a
Doesn't mean.
policy, it is an IP or 504 is a legally binding document for all parties, and so. I don't think there's anything, I haven't seen anything specific in one of the policies about extended time. But we know that all accommodations and services that are written in are.
Right, they're written into that.
Yeah.
Students. Went over grades and evaluation of efficiency.
Okay, so when it comes back again, I'll try
Yeah,
and make
It
it
might
better.
be in a
then.
different.
The other note I had was on, physical education, and it says that,
For which one?
once again, I think it's 5121, but again, I did not take a good set of notes on this, but I know it has to do
That's
with
okay, we're
grading.
ready for that.
It says that,
The AR or the board policy?
I'm not
Or
sure.
just the AR, because that's the only one where.
Yeah, I am not sure, because I was reading both and I may not have made a good note. It says something about you are not penalized for not wearing a PE uniform or something like that. But how does that apply to the program we just cut, JROTC, where I think you do need to,
They have a specific MOU with the Air Force.
they do, okay.
And one of the stipulations of that MOU that creates a challenge in that program is that no one can be required to stay in that class. So if a kid comes to the office and says, I want to drop AP literature, as a principal, you say, I want you to go to tutoring 3 times and see if you still feel that way, right? Like you put these guardrails up so that if you open a class of 30, you hold a class of 30. You cannot do that with JROTC because it's considered that they have corporal regulations, haircut, dress, physical activity. And so when a child comes to the office and says, I want to drop it, you are mandated per that MOU to say, okay.
Okay. Interesting. Okay, that's all I had. Thank you.
No problem.
I'll try to take better notes.
No, you're fine, and that was in this one, so you were right.
And then if we can group student records 5125 through 5125.1, release of directory. These are LARIs, and they are all keep CSBA.
Okay, I did have I wanted a little more of a explanation on, it says student records from social media and like something about parent permissions with social media and student records with social media, and I wanted to understand maybe what that means a little more.
So.
If I got it right.
So that was, so just so you know, within the student use of technology, there's a little bit about social media as well. Those are so the ones for student records as CSBA, we block all social media for students to use. However, we do know that students have their own phones. They are using cellular, they're able to get in that way. But in terms of records, and I'm trying to.
Yeah, so it says in the policy, and it's ed code. It just doesn't make sense to me. Superintendent or designee may gather and maintain information from the social media of any district student, provided that the district first notifies students and parent guardians about the proposed program, offers an opportunity for public comment at a regularly scheduled board meeting, and gathers only information that directly pertains to student safety or school safety or student safety. I have no idea what that means.
So I think that was specifically, go ahead.
I was just gonna say, they passed a law with a couple of years ago that says districts are not supposed to monitor kids' social media. And it sounds like these are the steps that they're putting in place for, if you are gonna monitor social media, a student's social media, that very limited reasons, and there's the process here.
Okay. Keep blocking it.
Oh, yeah, I mean, we do the best we can.
Okay,
We used to joke at De Anza that no one's cell phone got service except the students.
right.
Right, like,
Yeah.
you know, I get a call from a parent, my child posted on Facebook and they're in the middle of third period. Can you walk in and see what's happening? And I'm like, yes, but I couldn't even respond to a text.
So funny. Yeah, that's totally true. And the other question I had just on social media and kids, I mean, I'm supposing it's all FERPA and whatever, but data brokers and data slipping through.
Mhm.
Like, what do we feel about that, or
In terms of social media or just in terms of data? Period?
data, period, names, addresses, information?
So there's a piece in the employee use of technology, regarding, the fact that, about personally identifiable information. And how that you are not supposed to be sharing that at all, especially with an AI or with anyone. And we also have data privacy, policies in place.
Thank you, that's all I had. Just didn't understand what that was. Because they write things that don't make sense to anyone but them.
And are we okay moving the conditional release of directory board policy with these?
Yep.
Because it goes with the AR, right? All right, always a popular fan favorite, withholding diplomas and transcripts. 51.5.2. We're recommending keep CSBA.
Yeah, I didn't have anything, but I could see maybe this could be a robust discussion with the board. But I didn't.
It's the very rare cases where I've seen it attempted, it doesn't work. You know, give it out is what ends up happening.
Yeah.
So. Bus conduct, bullying, alcohol and other drugs, weapons and dangerous objects are, excuse me, with the exception of weapons and dangerous options, let's leave that separate. These are keep CSBA for bullying, alcohol and other drugs. Are there any questions?
Yeah, so on bus conduct, I wanted to know who that applies to. Does it apply to only buses that we run, like field trips? Is it contractors who do special ed students? Is it AC Transit? Is it, like, where's the line on?
So my understanding, and Mr. Scolar can chip in here, is that we're responsible for kids on their way to and from school. So
On
if,
any made?
yep, so if they're on AC Transit and something occurs, we still take over the response.
Interesting.
Discipline front, I think liability probably, because offering, you know, that's how they're getting to and from that all makes sense, so I can see. This apply to, say, AC Transit.
Very low.
And
That's not-
everything else.
Any other questions?
No.
Okay. And then the weapons and other instruments, we did mark as a discussion. And I know that, LaShante and Mr. Booker have been working on this one.
Yeah, the discussion that we had for the weapons, policy was more so related to, as a district, we could include a clause around pepper spray being allowed in a student's backpack, and not taken out during the school day. And wanted to have a discussion about other school districts who have that practice. Because some students bring pepper spray to protect themselves after school to and from, walking around the community. We've had several instances of pepper spray being found in backpacks on our campuses, never taken out, but a student disclosing that they had pepper spray on them, in case of, an emergency after school. So I did want to open that up for a discussion. We currently do not have it in our policy, but the CSBA policy had it as an option. And if we were to do something like that, we would have a regulation around a student letting an administrator know that they were carrying the pepper spray. And of course, if it was taken out during the school day or used during the school day, appropriate discipline would follow. But this is just the pure possession of pepper spray.
Okay, so I think that needs to come back for a discussion with the board.
I did want to ask a question since we have Ed here for the bus contact, just to clarify, when going on a public transportation, is it going to be like coming from a school sponsored event, or can it just be from anywhere as long as it's coming to the school?
What do you mean by that? Is it as long as they're coming to the school?
So if it's homecoming on a Saturday.
Yeah, okay. Yeah, I would say it's a school, it's related to a school activity. So if it's related to school attendance or a school activity and homecoming and a school activity, I would say that I would, if I'm I always put it as, if I'm a smart plaintiff's attorney, I'm going to say, yes, you're responsible.
I'll say from an admin standpoint, at the end of the day, it impacts campus. There's even things that occur that the school has no authority and discipline over. The problem is they create friction and discipline issues on your campus. And so you actually still have like a moral and safety obligation to create conditions for restorative conversations so that kids are safe at school.
Exactly, in regard to going to and coming from.
Yeah, and even beyond, right? So if it's Saturday and nobody went to or from anything, but there was a fight involving 10 of your kids and you have knowledge of it, you know they're gonna come to school Monday upset. You're not disciplined, but you do have a responsibility to like set conditions to protect the kids.
That makes sense.
So. Okay. Moving on, I'm feeling like we are, cruising right through here.
We're gonna be done on time or early.
You said it. Fighting words. All right,
We are gonna be done on time or early.
okay. There you go. So health examinations, I'm gonna bundle the next few. We would like to keep CSBA. Suicide prevention, we updated last year. We would like to keep our version, but adopt the AR from CSBA. Suspension and expulsion, we would like to use the existing district policy. Any questions about that bundle?
I didn't have anything.
Great. Look at that. Look at all those check marks. Okay, freedom of speech and expression, non-discrimination and sexual harassment. We are back into Mr. Espinoza's line and Title IX. So you want to run through these, Jose?
For the 51.5.2 freedom of speech, that one I did not work on.
That means I did it. So wonderful. Are there questions about that one? Or did you do it, LaShante? Well, maybe I missed it because I don't see an X here. Sarah, do you recall that one?
That's what I'm looking.
Yeah, I reviewed that and I didn't see any marks on anything, so I wasn't sure if that got looked at. I can definitely see a board discussion around that.
Well, why don't Sarah and I pull this to do another review, because most of these I have a pretty strong memory of doing, and so we may have missed one. Okay, and if you find something, Sarah, and I'm wrong, let me know.
What year CSBA version is that?
Oh, I could find that. Oh, I could actually find that.
5.5.2,
Yeah,
February 26th.
okay, yeah, I was gonna, that makes sense.
So we would likely
It's a
keep
new-
CSBA, but I just
You
think
just
we
wanna
missed
review
it.
it.
Yeah, I think we missed it, so we wanna take that chance to take a look at it.
For the other policies, 51.5.3, those just went to the board, so we're going to keep the district
Yeah.
policies. For 51.5.7, we'll keep CSBA with some edits. Same thing with Title IX, keep CSBA with edits.
Yeah, and I didn't have any comment on that, just definitions if appropriate, and I didn't see anything.
We are into the 6,000s. If I skip past conditional, you wanna be our driver for a minute, Guthrie?
Sure.
I mean, I'll keep it on the screen for you, but these are all yours.
Right? So 6159, we actually don't currently have an AR in the district, so this will be new, so we went with CSBA. And then for the procedural safeguards, 6159.1 and .2, both the BP and the AR, we wanted to keep district. This was already revised for CSACE. And then for .3, appointment of surrogate, we went with the district for the board policy, but CSBA for the AR. Again, this is a new AR. We don't have an AR currently for the district. That was several, so I'll pause there because I know there's a few more here.
Well, I just have a general question.
Sure.
Is it necessary for, this is probably an Ed question, is it necessary for the district to adopt ARs or BPs if the current policy does not have that AR or BP?
What do you mean?
So if the district has a board policy but not an AR, are we required to adopt an AR or vice versa?
No, I think it depends on, it does depend on whether. The short answer is no. If there's a statute that specifically says the district shall have a policy.
Right.
That says this, I would recommend having the board policy accompany. But there's nothing outside of that, there's nothing to require. Having the board policy and an AR.
The ARs though are listed here under the mandated,
Yeah.
which is why I moved them forward.
And it makes sense, but
Yeah.
Yeah.
Right.
This was animals at school. We went with CSBA on that one.
Wait, can I click these check marks?
Yeah, I didn't have anything.
Great.
I mean, I may at a later time after hearing discussion, but as of then.
Perfect.
And we actually did animals at school as well. We also recommend.
Oh, good. So let's hear what
We
you.
doubled it up, but we also felt like keeping CSBA.
Okay, now 6164.4 and .41, identification evaluation, and private school students, both we want to continue to use district. And I believe that's it for special ed, and summer, I think, homeless, education for homeless children. It's back to you. Were there any questions on those last two? Identification or
I didn't have
private school?
anything. May in the future, but don't now.
So I think you can check those.
Education for homeless children, what, I'm confused by our excess here. Oh, yeah, we wanted to use the district. It was very similar to CSBA. But there was some supportive language in ours that was a preference.
I didn't have anything. The only thing on the animals at school, has anybody brought a miniature horse?
Not yet, not yet, but we had a great, I'm hoping, we had a great conversation about that, and we looked up some pictures, which was really fun.
You know, my neighbor had a miniature horse growing up and I used to feed it on the way home from school, so.
So we look forward to someone using it and then getting to go visit.
Can we potty train them?
Apparently so.
Yeah.
They have to be house trained, is what it says of them.
Yeah.
I want to meet the person who brings the miniature horse as the service animal.
It's gonna be me. I'm gonna do it.
Putting on a miniature pig.
My neighbor's miniature horse was named Cadillac.
It's a great.
It was. All right, we're getting slap happy because we're near the bottom of the list. Supplemental instruction 6179.
That's me. So for this one, we reviewed it and we're recommending that we keep the CSBA language. Any questions?
Okay.
Site selection and development, 7150.
Whose is that?
Is that you, Jeff?
One.
7150, site selection and development.
Yes, we are just keeping CSBA on this.
Going once, twice, three times.
I didn't, I mean, the only thing that went through my mind is, if, Orbach, Huffington, if there was any reason that the facilities people needed, the facilities attorneys specifically needed to look at it. I didn't have an opinion on that, I was just wondering. I think the answer to that is no, so my question is answered.
And then we're in the 9,000s.
Yeah, so I made my changes. Yeah, so I just updated, I wish, we're gonna have to check back with Clerk Gonzalez Hoy on, the 9,300, some of them he did. Or the 9,200s, like the conflict of interest. I don't know what he found. There was some silent parts between our governance handbook and what we had in policy. We didn't see them as conflicts, but we saw them as being silent, so I don't know what he ended up on that. Meetings and notices, I put, where we normally meet in. I do have a question for Ed on agenda meeting materials. I would like to know definitively, when we publish agendas, we try and we have it in policy that all the supporting documents come at the same time. Sometimes that's not possible. We do get comments from the public occasionally that you didn't post the packet that went with this agenda item. You are in violation of the Brown Act.
Yeah.
Can you clarify exactly what kind of supporting documents need to get published with an agenda?
The supporting documents that exist, right? So if you are if there is a document that the board doesn't have yet, you're not obligated to provide it to the public.
Right.
So, you know, but you can have, as long as you're publishing the agenda and they know what the discussion is gonna be. If there's an obligation, once it gets to the board, then there's an obligation to post it or at least make it available to the public. I would say if your practice is there are some districts and some charter schools that don't publish.
I know.
And don't post any supporting
I know.
documents, right? So I think the best practice would be, if it gets to the board, get it online, if the rest of the packet is online. But there is, if it comes to the board late, the supporting documents, unless it's legally required to be published, you know, like, for example, a charter school staff report 15 days before the meeting, then you're not in violation of the Brown Act.
So if we put a sentence in that said something to that effect, if it comes to a majority of the board, it has to be made public to everyone.
I would say if it comes to so what's the scenario where it would come to one or two board members and not the rest?
I can't think of any.
Yeah, I would just say if it comes to the board, then it'll be made as available as soon as possible or as immediately as possible to the public.
Okay, notwithstanding documents that require legally required notification,
Yeah,
advance notification.
with the exception of documents that must be presented prior to the meeting according to statute,
Okay,
then documents that are presented to the board will be published or presented for the public as soon as reasonably possible.
okay, so I think I will add that so that we can stop that little bit of comment. And that's all I had, so that's it.
People will still be mad, but you'll be in compliance.
But I can point to and say, there it is.
Right. Right.
It's the not knowing that, is it? And if I could say it's in this policy, read it here, then that's enough. Okay, so that's all I had for mine, and I'll write that up and put it in meetings and notices. But the changes that we had for the board were very minimal. On the mandated.
Okay. Now we are looking at all of the CSAS. I don't know if those are grouped in our mandatory because they just say CSAS.
Okay, let's see which,
And what I'm
I
looking
see.
for, and LaShante, take a look too, because I just want to make sure, I don't know if you did these or Christine, I want to make sure nothing's in conflict with the other policy work that happened.
The only question I had was around the suspension and expulsion functions to be done with on parents.
Yeah, and the X says use district, that's what you also had chosen, right?
Yeah, but I know that there was discussion about something, I just want to make sure it's the same on the tradition of the beginning here.
It should be an X, not X, but yeah, we'll double check too. I guess all of these actually say use district. So did anyone who worked on any of these policies select something else?
I had previously handed in an LCAP, things I wanted to look at for the LCAP. I don't know if it's the board policy or the AR that they would apply to. And I'm actually not even sure I brought it today. But I will send that in.
I think whole 10 is the other.
And Catherine, the high school graduation,
Yeah,
this, that one, we didn't bring that forward, did we?
Or special education had edits that they needed to make.
But you've looked at it and it's okay.
It wasn't.
So this can't move forward because it hasn't been reviewed. Okay.
What number, which policy are we talking about?
I'm looking specifically at the high school graduation requirement. I just have a concern that the alignment committee hasn't reviewed this one. And it says keep CSBA with edits. I'm not sure if our team in college and career has looked at it, so I want to pull us back to make sure everyone's had a look.
So yeah, so what I did with that one is I took everything that we had discussed. I know that we wanted to keep our table and keep credits instead of courses. So where the CSBA has like 2 courses in this, 3 courses in that, et cetera, I removed that and I put the table back. So I essentially kept the pieces that we wanted and kept some of the CSBA language as well. So it was should be CSBA with that. Yeah, it's under CSBA exactly. So but I figured that there would be some discussion of that one anyway. So I think on the column to discuss,
Why don't
Sure.
you keep going and then I'll pull it up and take a look at it
Okay.
quickly, and then maybe we could look back to that one, make sure.
Yeah.
sounds good.
Because it looks like the others are either CSBA or existing district policy, so it's fairly status quo. That's the one, and then. Do you mind pulling that one up also, Jeff, so I can say this is
9,000.
it is 6146.1. Are we sitting in the dark for a reason?
Yeah, you can be on the lines.
146.11.
I got it. Susan.
I mean, I already stood up, I was ready.
Board policy.
Yeah. It said keep CSBA with edits, so it'd be the draft book.
Yeah.
61469.
Just 1.1.
6146.1.
The big difference, right, Guthrie, is the addition of the non-college prep credits for the special ed courses that count towards local credits for graduation.
Not exactly. The big difference is the alternate pathway. We didn't really need, for graduation, we didn't need to add the MMSN. Let me pull it up as well.
You care, okay, sorry, thanks for letting me borrow your.
This says last revised in. Oh, I'm wrong.
We revised it in the last few years for the adult ed piece.
Ed wants to say something.
I was gonna get back to you on the top of the meeting where we were talking about remoting in.
Oh, yeah.
You want, while we're on break, so.
Yeah.
There's two laws, one regarding school districts, I think that's SB 707, that is. For if a board member or a member of the legislative body is absent and appearing remote, or is appearing remotely, then you have to make it remote for everybody else. In regard to the legislation and that was due, that went into effect January 1 of this year. In regard to the legislation, I don't know what the bill number was that says. You as a legislative body, you have to have all of your remote.
Yeah.
That's just that, school districts, LEAs are excluded,
Oh, okay,
and that goes into effect July.
okay. Thank you.
Okay, I just reviewed the graduation one and it looks good to go.
You
Good to
in,
go for
We
me
just
too.
made an edit.
are you in the
I'm doing both.
workshop manual
Choose
side?
both. Yeah, we
Okay.
just made one edit, because we used the, district, the one option, so we just deleted the yellow that needed to be edited.
Yes, thank you.
Yep. So,
You're talking about this piece right here?
yeah.
And then there's an AI appointment and conditions of employment that says CSBA. I just want to make sure HR was consulted on that.
And they're gonna come back, they're just trying to finish off the policies that they've had.
Okay, great. And then trustee Reckler, the meeting agendas and notices in the 9,000s. I know we
Yeah.
said conflict of interest, we're waiting. Where did we
Yeah.
land?
Meeting and notices is fine. I think I made a few little, notes. It can be moved forward. Agenda meeting and materials, I'm gonna add Ed's sentence about when materials need to be made public. Other than that, it's fine. Meeting conduct is fine,
Great.
can be moved forward.
And non-discrimination use district. And your non-discrimination state use district, because you had just updated it, correct, Jose?
Yeah.
For,
Yeah, just making sure. I'm pretty sure 0410.
yeah, 0410, from what we were discussing with Mr. Fleischman is that it would stay
Perfect.
use district since it's going to the board for
Yep.
second.
All right, and then CSACE, Guthrie has the non-public. One is keep CSBA with edits, the other is keep CSBA. Anything on those?
No, one was keep district and one was keep CSBA.
Okay, and are there any questions on?
I didn't have.
Great. Local plan.
So several of these were actually reviewed by other folks, even though they are required under the local plan. Like the accountability and certification, I believe those were reviewed by somebody else. Let me see, hold on, let me pull back.
Are there any questions on the local
Yeah.
plan?
They're all used district though. Except for the 3 foster youth work-based.
Yeah, and the reason we changed Faster Youth to CSBA was the language was stronger around enrollment. Work-based learning matched CSBA exactly. Catherine, did you have anything to add on home hospital?
Oh, I have a question on home hospital. So I recently had a constituent who had a child with a long-term illness, but could not get the courses they desired at the high school level, like they couldn't get their AP classes. What do we do about those?
I believe that was resolved through 504 accommodation, but Jennifer, you might have more detail on that.
That's my understanding as well. Christian, are we talking about beginning of the school year,
Yes.
rising senior? We're all talking about the same student.
Oh, yeah, I don't know.
Yeah.
I don't know if it was-
Yeah,
Yeah,
and
it
I
was-
think we should probably answer
Yeah.
this offline because it was an extreme circumstance.
Okay,
And so I think the accommodations that child received lived very far outside of policy.
okay. But in general,
However, they-
do we,
They did.
it could be a general conversation. If the class isn't,
Yeah,
we decide what they got. I
We-
guess it's- would be-
essentially, we bend over backwards and do everything feasibly possible within what the child is able to do to give them access to the courses that they desire.
Okay, so we do that.
Yeah, yes, within what is reasonable, what is feasible, what the child is able to do considering their health conditions. And we work collaboratively. Obviously, parents in situations like that are going through immense grieving and things as well, and fear for everything that they've worked on for all these years. So we take a very caring approach and do everything that we can and work with them. In fact, even reaching out to one of the universities that student was interested in and getting a little bit more detailed information about what is to be expected. So yeah, we like Summer said, that one was a very extreme case. And so in general, though, we would always do everything that we can feasibly do within what, taking into consideration doctor's orders, health conditions, ability to transport or not transport, what can be done virtually, what can to individualize a plan to make sure that student has access to as close a facsimile to what they would have had otherwise.
And are there restrictions on what is offered under the law? I mean, is there?
It's not necessarily under the law, but if you look at home hospital and the purpose of home hospital, the purpose of home hospital is a short-term bridge to instruction. The credits earned in home hospital actually are not UC approved. So anytime we give a UC approved credit, there's an approval process through UC doorways. And then that also gets attached to when I taught English, you have to have the appropriate English credential. And so home hospital is this very direct service that's independent study for the child. The credits that go on the transcript are not eligible for four-year college.
Oh, that's.
So if we look at Vista or the virtual school, they are, but it's also an independent study program, a little bit more robust, right? Because they have a larger team of people, they can sort of do a few more things to tailor to students. Not that they can't offer AP, but a small independent study school cannot offer AP at the same level of El Cerrito High School, which is a large school. And so when we look at these alternate options, they're designed to really meet kids' focus needs in the moment. It's not about accessing a high level of AP. So in 19 years in high school, this was the first case I had seen where we had the convergence of time of life, college application process, school, which made it really different.
Oh, okay. So if that were to happen again with another student, like, is there a timeline for home hospital and then would they switch to Vista? Would they transfer to like, how would that?
So I think there's
Just-
always gonna
just
be,
general.
yeah, I think there's always gonna be an evaluation. I mean, when we do home hospital, we're like, you are homebound, right? Like you can't move. You need a lighter touch even than probably Vista virtual. It is intended to be short-term. Students are out for a period of time with a doctor's note, and the intent is that typically they would come back to the homeschool. But if something is going to take several years to resolve, Vista Virtual may be a great option or a great bridge.
Okay. All right, yeah, I have a lot to learn about that. It's interesting. Okay.
So local plan, are there any questions on the rest of these?
I mean, the only thing I have on LCAP is I of course brought the policy, but I don't seem to have my notes. So I'll submit that separately.
Sorry.
I'm sorry, LCAP or local plan?
No, I'm back up on LCAP.
So
I don't have
I'm
anything.
checking all of these boxes. We have done all of the mandated. Do we want to take a quick stretch break and look at the conditional?
Sure.
Okay.
Is 4112 check, Kelsey?
Um,
It's not, I just wanna, I can check it.
you should give that, Lori, should. Okay. Take a quick, go to the bathroom.
Any public comment?
Oh, yeah.
All right, we could take public comment.
I
Is
don't
there
know
any-
that we have.
Is there any public comment on anything that's been presented so far?
There's no public comment.
All right, so let's take a break, be back at, what, noon?
Yeah, that's great.
Noon? Okay, we'll be back at noon.
Donuts.
All right, everybody, we're back.
I'm feeling too bad, and then.
All right.
All right, we're back. Starting again.
All right, so thank you, Sherry, for reformatting our sheet. So that our conditional policies are on top. This first one, conditional is yours, Guthrie, 0430, and the recommendation is East District. Any questions?
No.
Great. School bus drivers, 3542, is that also you, Guthrie?
It was, this one, we were recommending not to bring forward because we don't hire school bus drivers. It's not a position in our district.
Yeah, I had a question about that. So do you, my question was, can you take there seem to be, in all these school bus driver policies and stuff, there seem to be some good things. Do you put those in contracts with Michaels or with, like,
The elements of these
yeah,
CSBA, I'd have to defer to Jeff on that.
I would have to look. The contract itself is pretty thorough. But
I would recommend they get read, and I thought there were just some good things that if they're not in contracts and they could be, that they should be, just about.
for determining their drivers,
Yeah, and conduct and,
I don't know.
maybe it's covered by the law, maybe it's not.
Yeah, I don't know if they would allow us to.
Yeah, I don't know.
determine their employee policy and
Yeah,
contract, but
Right.
we.
And they are unionized as well, they're drivers and.
They're already Teamsters.
Yeah.
So we could have it as a board policy and ask them to review our board policy to make sure their drivers align with our board policy, but it's not something in place at the moment.
Yeah. I do.
We're removing that or?
My
Yeah.
recommendation was that we don't move it forward.
That's fine.
Yeah.
Okay. Our next bundle is all for Jeff, around food services and the sale of food.
Yeah, we have CSBA, on all of those, no edits.
Okay, and 3551, I think there was an option, I'm assuming we're option 2. Oh, it was about paying people, we paid them out of the cafeteria fund and not the general fund.
Mhm.
Okay, that was just more for my information.
You're okay with moving?
Yeah.
All right. Drug and alcohol testing for school bus drivers, I'm assuming this doesn't move forward for the same
Same.
reason.
Not our employees, they're unionized, I don't know that we could
It'd be hard to enforce it.
enforce conditions of employment.
But I hope that that's right. Right?
Did they have drug enough?
Or hope, right? That's in the contract, right? That we're insisting that they.
Having just reviewed our drug and alcohol employee policy, it is very clear. All right, we are at assignment 4113 as an AR. Does our HR team have a recommendation on this one?
CSBA.
Any questions? And then actually these next pre-retirement awards catastrophic leave, what are your recommendations on these?
We're gonna, keep the district.
For all three?
Mhm.
Great.
Yeah, so it didn't seem to me that we had any of these, or we didn't have 425, 425, 6. Okay, so it looks like we had 4156.2, but we didn't have on the books 4256.2 and 4356. Now they're triple. It's one of those triples, so would you add those 4256, 4356, or just leave it with 4156?
4156.
Okay.
Four, 4256 that. Two, you have a policy.
You do have that? I don't think I saw.
It says
that.
adopted in 2010, last revised.
Oh, really? Oh, all right, I might have missed that.
Inflation, not achieving dollars.
Okay, no problem with that.
Any other questions?
So we're gonna keep all three, right?
Correct.
So whoever just crossed those out, maybe.
Yeah, because you said we're only keeping the 1415.
Oh, I'm sorry, not keeping only the one, sorry. The 4156.2, yes.
4256.2, we're keeping it or removing it? We have one.
Keeping it.
Keeping it.
Okay, and then 4356.2.
We'll be removing that one, those, two, we're just keeping the first one.
No, the first
So the
one's
first one will apply to all employees?
Yes.
So are you updating language, or should we update the language? It says that it applies to all employees.
So we updating the language. It's the same.
Oh, we have all three, and they're all three the exact same language.
That's what I'm saying.
Yeah. I mean, I'm fine with getting rid of them because I don't think we need to see it twice, but I think it's important that it's indicated that it applies to.
Particularly if it's found in one of the classified, the certificated employee section. If it's gonna be 41 number, then probably, yeah, just making sure that it's indicated this applies to certificated and administrative.
Yeah.
Classified administrators.
Yeah.
Because otherwise you won't know.
Yeah, so how do we know which one, like when they're triple coded, which one to keep? If we just want to keep one.
I don't know. They didn't teach me that in law school. I don't know.
That be a CSBA question? Maybe they would know.
We're wouldn't it generally be the first one, so if,
Yeah,
We could recommend.
I mean, you want 56, if like this one's 4156, we'll keep 4156 versus 4356.
yeah, and I think if you're mentioning all employees and you're having it in the 4100s, that's fine. I think you just want to be, my thought is though, as we're talking about this, you want to be consistent, right? So it's not like you're triple coding for some, and you only have one for covering all. And then somebody makes the argument, oh, or somebody says, I didn't know that applied to the administrators. So,
Yeah.
because you triple coded in these sections and you didn't triple code here. So I think
Yeah.
you just want to be consistent.
So bringing it back to like our policies for sexual harassment or Title IX for employees, if we only keep first 411912, we don't do it for 4311912, then can that employee say, well, this one didn't fall under me?
I think you want to just make sure that the language of all employees are covered.
Yeah, and usually they typically do.
Yeah, so I think you're fine.
Okay, so we're good with this pending our just straightening out the coding. Okay.
So
Thank
that's
you.
the same question too for the catastrophic leave, this triple.
So you want to keep the district but reduce the coding?
Yes.
Okay. And then did you have a chance to work out 4218?
Oh, in the.
Yes.
The first one.
It's, CSBA, version of it.
Great, and do we have any questions on 4218?
No, in general, in this entire category, my reading of our 4000s versus CSBA is that in general, I preferred CSBA's more because they were just more descriptive. But I didn't see major differences. So that was just my comment on that.
Okay, great.
I also wanted to bring up a comment about the triple coding. If we're removing the triple coding and only keeping one, I did speak with Jennifer over CSBA and she said that if those additional policies are within CSBA, that we have to go in there and click remove. Or if we're gonna edit them, then put keep with CSBA, but if we're only gonna keep one of the three, then we need to input remove those policies.
Yeah, so that's gonna, yeah, right.
All right.
Oh, if I could make another general comment about the 4000s, there were a lot of things in here that probably need to be reviewed with the collective bargaining agreement. So, you know, I didn't specifically know what was in every collective bargaining agreement, but that needs to get. There seemed to be some very specific things that needed to get double checked.
So if we look then at conditional 4218.1, it says merit system, not sure what the difference is.
Yeah, me either.
We're not under.
Okay, so
what is that?
so basically the recommendation is to pull this,
To remove.
remove this.
Under. Gross, got
Okay. Great, and then we're back to evaluation and supervision, 4315.
CSBA.
Any questions on that?
Is there anything in the collective bargaining agreements that, are not in the line?
I'd have to verify with all of them, because they all have varying, contractual guidelines.
So do we want to move this one forward or wait for the confirmation?
I'm not that debated, I don't know.
I think we can move it forward, because the contract, because I have to meet with one unit and get ready for negotiations with another, so that will definitely hold it up, so. I think it's, I want to say generic enough right now.
Okay, great. And then we have these three conditional, the student and family, or excuse me, the two student and family privacy rights, Laurie.
privacy rights.
Uh-huh.
Which number now?
5022, 161.
Does that mean I did them and just cruised through the way I did all the
Yes, I am.
5,000s? I bet I did it, and I said keep CSBA.
So in 5022.
Can you pull that one up, Jess?
Is this the board policy 15?
There's a board policy and an AR that are conditional mandates.
Okay, so in 5022, the student and family privacy rights, there are two options. There's a number 1 and a number 2, so I wasn't clear which option the district was recommending.
We kept the option, okay, good, looking at this jogs my memory. We were keeping the option that we previously had in our original policy.
And it has to do with collecting information.
Can you pull up that current board policy, Jeff? No, so there was a glitch in our inputting. Are you able to pull that up, Sarah, and we can come back to 5022? We left the option the same as the current district policy, but can you do the compare view so you can find that? And then whatever ended up in our draft has all three.
Okay.
So we'll just, if you can edit that, then we'll come back to it. Okay, great. Student wellness was keep CSBA with edits. This was the one we also wanted Barbara to review.
Okay, wait a minute, which one is that 50/30?
Yeah, 50/30.
Okay, so for 50/30, I had a question. Oh, also on 50/22 on that administrative regulation, I liked it.
Great.
Um,
And I'm having Jeff pull up 50/30 because I think this landed in ours, and then we also had Barbara take a look at some
okay,
pieces.
that one I had a question. Let me find that one.
Who's gonna send it to me straight? I don't know.
We put it in there though.
Yeah, she.
Okay, so
So, okay, you sent me an email saying she did and she was fine with it. Okay.
okay, so in 53rd board policy 50/30 and student wellness. It says that the board may enter into a joint use agreement or memorandum of understanding to make district facilities or grounds available for recreational or sports activities outside the school day and to community use facilities to expand student access to opportunity for physical education. And that was struck, and I just wanted to understand the reasoning.
I think that we just struck it to not complicate it with the facility use
Okay, that's fine.
policy. And I also, we're part of Richmond Plays. I think we do that. But it was something in my thinking, I didn't want someone to pull that and think that it
Okay.
was in conflict with another policy.
That's what I thought. I just wanted to make sure. And then it says down here that we're supposed to put a person who's responsible for all of that, and I didn't see that in the.
And that was a question for your team, Jeff. The person responsible likely is Barbara, but and so Sarah, you can probably just edit that right now and
Yeah.
fix
Which
it.
one?
That Barbara is on policy 50/30 under the title, position, phone number. Okay. Admission is one that we did ask to bring back after having a legal review, same with residency. So we can go down to student leave of absence. And LaShonte will be ready for questions
Yeah,
on this
that's all
one.
questions.
Are you looking for your questions on that?
Oh, no, I thought she was gonna go. Oh,
Oh,
sorry.
I know. Go ahead, LaShonte. We're all being busy, be polite.
Yeah, the policies are pretty much the same. Our policy that we had, but the policy that we're adopting from CSBA just includes the language that really the board recognizes the importance of regular school attendance. And regular school attendance promotes positive student achievement. So it just, is a preface to the language that we already had that we added.
Okay. Um. So how, I had questions about, I guess it's more in the AR on this. How, how long, how long does this last and how are, like, do we have a lot of these?
Do we have a lot?
Yeah,
No.
leaves of absences.
No, we, typically it's done through an independent study,
Okay,
and so. I mean, we don't have. A normal amount, I think we have a normal amount for a regular school district of our size.
okay, and is it in the parent handbook?
Yes,
It is.
it is.
Okay, that's all I have.
Great.
I think the AR on this is important.
Okay, and so I'm skipping the boundaries and enrollment pieces again to bring it back. And going to awards for achievement, which was keep CSBA with edits.
Yeah, what's that number?
5126. And Catherine, did you do that one?
I did, yeah, we just have, the SBA. And we took out one section that has a scholarship and loan fund, which we do not.
Yeah. What is that?
Yeah.
That's not ed fund. That would be something internal to the.
Yeah, I think I have it. Yeah. I think that's. And yes, so for the AR, we also did the same and just suggested it to not include that.
Yeah.
Weapons and dangerous instruments. I thought we already did this.
Yeah, you already approved.
I must have
For
mixed.
discussion.
We discussed it already, I thought.
Yeah, and that's above,
Board.
that's above my pay grade, so
It's
that's
this-
going straight to the
there's a-
board.
Got it.
That's with the whole board.
Got it. Not just move it in this group. Got it. Keep me on track, please, my friends. Okay, 5132, dress and grooming. We recommended to keep CSBA.
Yeah.
Administering medication and monitoring health conditions. Guthrie, keep CSBA with edits.
Yes.
Questions?
The board will have to make a decision
Yeah.
about medical cannabis.
Yep, that's
Um,
above my pay grade.
So there's two options. I did not pick an option.
Yeah.
Because there's gonna need to be a thorough conversation.
Yeah.
Okay.
For sure.
Great. And then moving on, required parental attendance. You did that one or I did that one?
You did.
Oh, great.
Right, we're
Wait.
looking at LaShante.
No, actually, I did have one. It's just, I did them the first week we got them, so now I have to remember back. But we did say keep CSBA, and we're legally mandated to provide attendance and attendance options for parenting students, and we have those.
Yep.
Freedom of speech and expression. Oh, we said Sarah and I somehow missed that, so we're gonna bring that one back. And then childcare and development, Catherine, this was one I actually threw to you like this week.
Yes. For this one, we suggested that we, keep CSBA for the board policy and for the AR, we just edited to include, I believe our local coordinator, over preschool programs.
Before and after school programs, we're recommending keep CSBA. And then the next set is preschool.
So we've got, for the board policy, we're recommending that we keep CSBA, and then for the AR, same. We are predominantly keeping CSBA and just editing to include our local staff. Any questions about that?
I didn't have anything.
Parent involvement, we are recommending to use the district version that we know that our parents had extensive input on.
Yes.
And that the AR should be CSBA. Ceremonies and observances.
Sorry, I'm like, oh, Summer, you're on a roll, I love it. So for ceremonies and observances, we kept CSBA, and just edited for the context, and I can, unless you have specific questions, we can also for course of study, we just brought that to the board, and so we're suggesting that we use the district. And then, for extracurricular and co-curricular activities, we're suggesting that we keep CSBA, and that's the case for placement in our math courses and, independent study, we tailored to our context. Specifically, the edits were around, am I sure you could open it? Sorry. Oh, this is where you might have seen the edit you were talking about earlier, and so what we did is in terms of leniency for, excessive of independent study assignments, we wanted to make sure that, students. Yeah, I know. Screen there. Every 2 weeks. Yeah, we adapted it to our local context, and so for our current practice in West Contra Costa, students kindergarten through, 8th grade are allowed up to 10 days, and, for adult students in grade 9 through 12, it's 3 weeks, so 15 days.
Okay.
And then if I keep scrolling, I think that is the only other edit that we made to match our current practice. Then I think that takes us, unless there's any questions, to the use of technology, which Laurie did some extensive work on.
Basically what I did, and I can say this about student use of technology and employee use of technology as well. Basically took what we already had, which our most recent technology policy is the one around AI. And it is very well written. It's a district written one. And I just took that and made sure that student use of technology and employee use of technology sort of incorporated those. And so it's basically CSBA edits.
Okay.
Yeah.
And so would we keep our AI policy?
Yes,
Okay, so.
because I did compare it to the one that CSBA has, and ours is actually better.
Okay, good.
Yeah.
Somebody's gonna have to go back to that deletion sheet, because I think I noted on there that possibly that one might disappear, but if we're gonna keep it, then.
Go ahead and keep it.
Okay.
The AI,
Yeah,
definitely keep that.
yeah, so I'll make a note to take it off that sheet.
And that policy's not on this sheet that I'm looking at, is
No.
it? Okay.
Yeah,
Because
so,
it's 2024.
yeah, and they're the ones that have the pointy ones, the ones that are district specific, CSBA didn't pull, and I didn't realize them until after the fact, and I was like, oh, we have all of these that we didn't look at because they weren't on a sheet, so I don't really know what we're doing with those yet, but they may disappear because they may be in CSBA. Right, that's.
Jeff, Title I program 6171.
Yeah, so we're taking CSBA, but we're making very minor edits to align with the CDE documentation around Title I. So FPM was just here and they reviewed it, so we're just making minor edits to the Title I.
Oh, I'm sorry, can I go back to your, we had that brief discussion about a district technology plan?
Yeah,
That is not required anymore by CSBA.
right. Yeah, okay, that makes sense.
Yeah,
Yeah.
so the question would just be, does the board wanna maintain something?
Right.
Yeah.
Okay, thank you. And then, so employee use of technology, you're okay with that?
Yeah.
That one should get I'll let.
Oh, I'm
Summer
sure
do
there'll be discussion.
Summer do the checking on that one. It's 44.
Yeah, I didn't have anything, but I could see that being a
44
board discussion.
employees of technology, and then there was, because we were down to
40, 40.
40.
It's not on here.
Yeah.
40,
Yeah, it is.
Am I blind? There it is.
or 34.
Yeah, it's very, yeah,
All right, I got it.
thank you.
All right, our CTE policy exactly already matched CSBA.
Great.
And it looks like I missed the regional occupational center program one, so I wanted to pull that one back and look at it. We don't currently have that. And typically they're more county run. So very likely I would recommend we pull this one out since it doesn't exist for us, but I do want a chance to take a look. I just didn't see it on my original list. Something not really bad. Okay, Alt Ed.
So adult education is mine and in consultation with our, it's like I timed it perfectly. We are keeping the CSBA. It's a strong one.
Did you do the continuation or did I do that?
You did it.
Oh, keep CSBA. Yeah, and it was minor edits.
Okay.
Yeah, I did that one. We updated, a section that we hadn't had. Good office.
Any questions on that? Okay.
And that was one of the, NPM findings.
Oh, great. So we're in compliance on two fronts.
Correct.
Melrose District 7212.
Yeah, that's mine.
We're not one, right? No. Roos
So
district,
Melrose.
we're not a Melrose district, right? No,
Do we want to remove it?
yeah,
Okay.
right? We don't need that, Ed, no.
And then we're back at conflict of interest, which
Yeah, so I don't know what he, oh, there were some notes there. What does that say? Can you move that one?
Uh-huh.
Check.
check back with,
Oh, yeah, okay, there we go.
I took the notes. So, we have made it to the bottom of the list. Is there anything that we want to revisit?
I think we're gonna go back to some of the HR ones.
From the previous, we
covered them already.
yeah, we ran them at the top. Anything else?
Just want to go down the list really quickly to make sure all of them are marked.
Before we do the.
Yeah, and then we'll go to public comment and then just some next steps on. what we-
Actually,
what we wanna do.
for the student and employee use, I'm not going to be here for the March 25th meeting. So it's okay if that goes in June. Those two,
Okay,
because
but we also said they're okay right now.
they're, no, they're not. Are they mandated? No, they're not.
They're
Position.
I could have 61.
Because that's something actually that I mentioned. Yeah, it's in the condition.
Yeah.
So they don't have to go.
And if there's not, if we don't think there's questions, they can go whether you're there or not.
Yeah, but yeah, we can.
We're looking at the form, it doesn't look like we discussed 5022. Unless,
I'm working on that.
oh, you're working on that one, okay, great. So, did we already discuss it, that we could check it out?
I just did so.
Great. Great, so we'll mark that out. And then what about admissions?
Those are all, we pulled several
Okay, perfect.
that have to do with
Yeah.
enrollment, yeah.
And then we're gonna discuss weapons. We're gonna discuss medications. Freedom of speech and expression. That's one you're gonna have to.
Yeah, we have that one.
Bring it back. Okay. Ooh, I like all these specs. Yep. And this one was? That one's. And then, okay, that's exciting.
I have a question. Ones that we're saying to discuss, are we still bringing them for first read, but those are just gonna be identified for discussion?
Yeah. I mean, I think there are some things that do need board discussion. I personally have a little list of the things I think will be discussed, but that's just, knowing who I sit with on the board. And maybe, I don't know, you'll have to work with the agenda setting team, but about how to bring this all forward. Maybe like part easy, oh, actually, they're actually going into the next. All right, why don't we hold on that for just a second? Is there anything else on policies? Because then we'll take public comment, because then there's an item which is next steps where we can discuss it. So is there any other review on what we have? Okay, is there public comment and anything else on the policies presented?
There's no public comment.
Okay, so then we'll go to 4, which is next steps. So, it's how to agendize this. And I don't really have a lot of answers on that because I don't know what's coming to the board. I think it is a priority for us to try and move through as much as possible, but again, I'm not on the agenda setting, so I don't know. And that, you're gonna check with CSBA and see if they can
Pull the whole.
pull like
Work
a
in progress.
Yeah, like, so that you're not doing a lot of that work.
Mhm.
And maybe, there's some thought given to balance, like, these are gonna be no-brainers. These are gonna require discussion so that there's some sort of balance, and so you don't get a
Yeah.
meeting that goes on for 6 hours because we're discussing micro points about.
Right.
So maybe that's an idea. Does anybody else have any ideas about how to bring it forward? The other thing that we talked about but didn't happen and would be nice is if the board got a notification that this huge thing is coming so that nobody's surprised. Yeah, so there's gonna have to be some discussion about how to bring it forward so that it's not overwhelming. I don't know the answer to that. And then on the triple policies, there's gonna be some decision about how to not throw that back, and so it's,
Yeah, I think each department's going to work on their triple policies and remove them.
yeah, that'd be great.
So in terms of agendizing, I mean, it seems like we know what we think is discussion. Can the other go in a group and say, we recommend this as a group approval, and then they can pull it?
Yeah, I mean, yeah, something like that.
And then the ones we know merit discussion, we list as discussion items.
Well, they're all gonna have to come for a first read, but there could be no, like it could just be agendized as this is a first read, these we don't think are
Yeah.
controversial, or there are minimal updates, this is the group that we think you're
Yeah.
gonna,
And then an
that we wanna bring to
individual
your
just be-
attention. or
Yeah.
Whatever, and as long as they can see them and they have access to be able to see what was existing and what the change is, that's fine. But I think some guidance is appreciated. And maybe they come, like, maybe they come. If there's a logical order. Like maybe it's all the 1000s, maybe it's all the two, like, I don't know how to do that.
All on the same agenda. These are all gonna be on one agenda. Then the planning board.
I don't know about that.
That's a thing.
I don't know.
That's
That's gonna have to get thought through.
Yeah.
Yeah.
But I can see setting up some type of consent agenda, like as a consent agenda item.
Yeah, but our board policy says that everything comes for a first read,
Yeah,
but we can agendize it as, this is a first read, but we don't think these are controversial. Read them, but we're gonna expect that, there's just not a lot here.
Yeah.
This group, though, we do have things that that we need to bring to your attention, or,
Is that all right, calling it controversial or not calling it controversial? Is that?
Or for discussion.
Yeah,
For, I mean, like carrying a pepper spray,
Yeah.
that's gonna need to be discussed.
Yeah. All of these have been reviewed by the governance committee. These are the ones that we think should have
Yeah.
discussion with.
Yeah.
Yeah.
But board members could choose to pull,
Pull.
that wasn't on there, that
Right,
they wanted to
anything,
discuss, yeah.
I mean, for me, it's that everybody gets to see them and has a
Yeah.
say.
This is the
That's the
recommendation
important-
from governance, that these are the ones we discussed.
Right, and it's beyond us. There's people, there are teachers, there's, I mean, people may wanna say something
Chime in.
about them, and I think that's important. Cause I think you'll get a better product.
But I think, yeah, I'm always advertising the fact, this is a public meeting too. where people could have the opportunity.
But it's during the day.
Yeah.
Mhm. Yeah.
Teachers are teaching.
Mhm. Yeah, other comments on that about that.
I just try to be sensitive to that.
Yeah.
Okay, are there any other questions on next steps? Okay, and then next meeting, do we have one? I think we do. Hang on. Hang on.
I have it for April 30th.
April 30th. Okay, so the next meeting we have scheduled is for April 30th.
So we'll bring back the enrollment and residency policies for that meeting.
Yeah. Yep, and anything else? And with that, we will adjourn at 12:42. Thank you, everybody, for your hard work. This was a lot. And everybody have a good afternoon.
Thank you.
And then.
Ended early